All right. I wonder if we're at 370 yet. Let's look. No. We're at 363. 363 videos in. Whew. Whew. Yo, that's a lot of videos. It's like when you get this far in Bleak House. You still have this far to go. Sorry. It's an old book. Okay. I'm going to press play. Make sure my speed is correct. It should be. I didn't touch anything. But it doesn't mean anything.
And were you aware of whether or not Mr. Simpson
She looks terrified.
suffered with any kind of condition, physical condition?
I know he has an arthritis.
Arthritis?
Yes.
And how do you know that?
The way he walks sometimes.
And you can see that?
Yes. The way he walks.
All right.
I can see it.
And was the taking of the carrot and celery juice in any way related to this condition of arthritis?
Same objection.
Sustained.
If you know.
Sustained.
All right. Do you know why he drinks carrot and celery juice?
Objection. After the answer.
This,
Sustained.
very well, I have nothing for this one. Thank you.
Mr. Darden.
Good morning. Well, afternoon.
Good afternoon.
And we met before.
Yes, we do.
You and I, we met in the grand jury.
Yes.
And that was the first conversation we ever had.
Yes.
And we haven't had one since.
No.
And you are, what is your position in the Simpson household?
I'm Mr. Simpson, housekeeper.
Okay. And you became his housekeeper in April of 1994?
Yes.
Okay. And do you recall the date?
Maybe second week, around April 10th, something like that.
Okay. Something around the second week of April?
Yes.
Okay. And the murder...
But prior to that, I work like on Monday, just to start if I will, just a trainee, if I will like the job or not.
Okay. All right. So after you began as a housekeeper in around April 10 or in mid-April, the defendant left and he went to Puerto Rico, right?
Yes, he is.
Okay. He left right after you were hired as a housekeeper?
Yes.
And then he was he back in May?
I think he's back April, the last day of April.
Okay. And after he returned, he stayed home for a day or so?
Yes.
Okay. And then he was back on the road, is that right?
Yes.
Okay. Going to many different cities to play in golf tournaments and other types of appearances?
Yes.
Okay. And so is it fair to say that he was gone most of the time?
Yes, he is.
Okay. So you really get to see very little of Mr. Simpson, or you did, right?
I'll see him from every time that he's in town,
Okay. But he was out of town most of the time?
mostly.
Okay. And so during that time period between mid-April and June 12th, you really didn't see a whole lot of the defendant, did you?
When he's at home, I will see him.
Well, how many...
But he's in May. He's in and out of, the house.
Okay. Now you told us that normally you would have to be at the house anytime the defendant was out of town. Is that
Yes,
right?
I do.
Okay. If he spent the night out of town, you were supposed to be at 360 Rockingham, correct?
I don't need to be there at the daytime. I need to be there at the nighttime. He just wants somebody at nighttime in his house.
Okay. Well, on the night of June 12th leading to June 13th, you called the defendant, right?
Yes, I did.
Okay. And you knew he had to catch a red-eye flight to Chicago?
I know that he's leaving town that night.
Okay. And you knew you were supposed to be there that night, correct?
Yes, I do.
Okay. And the defendant told you you didn't have to go there, right?
No,
Or will.
no,
Well, you didn't go to Rockingham that night, did you?
I did not.
Okay. And the defendant was your employer, right?
Yes, he is.
Okay. And had he insisted that you go there, you would have gone, right?
Sustained. Sustained. Calls for speculation.
Well, you asked permission.
Yes, I did.
Okay. You asked permission to stay out at Knott's Berry Farm.
Yes, I did.
Did you ask permission to stay out there all night?
I asked.
Is that yes or no?
But you can't answer the question.
I asked Mr. Simpson if I can watch the show with my family that night and come back the next day in the morning, and he said yes.
Now, you arrived at Rockingham the next morning. Is that right?
Yes, I did.
And you arrived there at about 10 o'clock in the morning?
Somewhere 9 to 10, around that area.
Okay. And you were interviewed by a police officer. Is that correct?
Yes, I did.
You were interviewed by a female police officer?
A female police officer and a man police officer.
Okay. And you told that police officer that you had talked to the defendant the night before at 8 o'clock, right?
Yes, I did.
Okay. And you told that police officer that the defendant told you not to?
Yes.
Well, I'm not reading from a report, Your Honor.
Is there a report regarding this?
There's an FI card which Mr. Cochran has had for 11 months.
Do you have the FI? All right, will you show Mr. Cochran the FI card, please?
You told that police officer that, maybe, hold on just a minute,
Yes. All right, proceed.
and you told that police officer that the defendant had told you that you didn't have to come back that night, correct?
I told the police officer that I talked to Mr. Simpson that night and I asked him permission if I can stay out and come back that morning.
Okay. That's what you told the police officer?
Yes, I did.
Have you seen a small card called an FI card, a field identification card?
Sustained. Sustained. Rephrase the question.
I'm asking the witness if she has seen the card, Your Honor.
Right.
You know Mr. Cochran, don't you?
Yes, I do.
You've been interviewed by Mr. Cochran, haven't you?
Yes, I do.
Okay. Let me show you the card, a field identification card. What is people's next in order, Your Honor?
I'm sorry? 534.
I'm sorry?
534.
Now, let me show you what has been marked People's 534. I ask you to take a moment and read it to yourself and read both sides, please.
Right, so you're going to be read the other side. The other side.
It's only my address and
Okay.
it's nothing.
Mr. Jared.
Okay. Now, did Mr. Cochran show you a Xerox copy of that card?
No, she
No one has
didn't.
ever showed you a Xerox copy of that
No.
card? Do you know what that card is?
No, this is the first time that I saw this card.
Well, when you were speaking to the police officer, did you notice that the police officer was writing?
Yes, she just asked my name and took the plate number of my car.
Is that all
And she asked me, and I asked her if I can get in the house. And she told me, no.
Okay, let me stop you there. She only asked you your name, is that right?
Yes, where do I live? My address. And she take.
Oh,
she
she's
write my
annoyed
plate
right
number of
now?
my car.
Okay. Now, what you're doing right now is you're looking at that card, right?
Yes, I did.
Okay, and by looking at that card, it's helping you to recall all the things that she asked, correct?
Yes, my phone number.
Okay, and does this card have your phone number on it?
Yes, it is.
Does it have your weight and your height on it?
Yes, it is.
Does it have your birth date on it?
Yes,
Does it have your place of birth on it?
yes,
Does it have your California driver's license number on it?
yes.
And did you show her your driver's license?
I don't recall that I saw it. Maybe I did.
Okay, well, looking at the driver's license number on it in the upper left-hand corner, was that the driver's license number?
Yes.
And does it also indicate what you wore that day?
Yes.
And does it indicate that you have a nickname of Gigi?
Yes, that's how they call me.
Okay. And this is all information that the officer obtained, well, most of that information was obtained from you, right?
Yes.
This is what you told the officer.
Yes.
And on the back of the card, it also has a description of what you told her regarding your conversation with the defendant, right?
Yes.
Doesn't mention anything about Knott's Berry Farm, does it?
Sustained. Rephrase the question.
This is Cross. Does the card mention anything about Knott's Berry Farm?
No.
Okay. But all the other information on this card is accurate, isn't it?
Yes, it is.
Overall. It is, actually. Would you re-ask that question, please?
Well, is all the other information on this card consistent with what you told the officer?
I told the officer that
May I have a yes or no answer to that?
Right. Was it consistent?
the information about myself is consistent.
Yes, thank you. Next question.
Okay. Now, the card also indicates that the time in which you spoke to the officer was 1000 hours. Is that right?
Yes.
Okay. 10 o'clock in the morning?
Might be.
You didn't tell the officer anything about Knott's Berry Farm, did you?
Overall.
She didn't ask me.
So you didn't tell her?
Yeah, because she did not ask me.
Okay. So the first time you told anything about Knott's Berry Farm was when you told Mr. Cochran?
No.
Now, who did you tell first?
About Knott's Berry Farm? Nobody asked me about Knott's Berry Farm. They just asked me if I talked to Mr. Simpson that night. And I told them that I called him from Knott's Berry Farm.
You told the police officer that?
I did not tell the police officer because they did not ask me. They just asked me, when was the last time you talked to Mr. Simpson? I told them around 8 o'clock that night. They didn't ask me where I am.
Now, you are, you take care of Mr. Simpson's clothing, right?
Yes, I do.
And during the month of June 1994, he owned sweat clothes, didn't he?
Sweat clothes?
Yeah, like sweatpants and sweatshirts.
I don't recall that. He has. All the things that I prepare for him is golf pants that he usually wear and denims.
Okay. Well, it's your job to make sure that all the clothes are lined up in the closet by color, right?
Yes.
To make sure everything in that closet is neat, correct?
Yes.
To make sure all of his clothing is clean, right?
Yes.
You do all the washing, correct?
Yes.
And you
Not
co-
all of it, because some of his clothes need to bring to the cleaner. So some of his clothes need to bring to the cleaner, not all of his clothes.
Okay,
I
well, with the
wash.
exception of the clothes that have to go to the cleaners, you wash those other clothes, right?
Yes, I do.
And you're telling us you don't know whether or not he owned black
I didn't see any black pants there.
You've never seen any black
No.
sweatpants? Never ever.
Never.
Have you ever seen the defendant wearing black sweats in any video?
No. I never watched the video, only the pregnant video that I watch.
Well, if the defendant owned black or cotton sweatpants, if the defendant owned black sweatpants, you would know about it, wouldn't you?
I didn't see him wearing that black sweatpants, so I cannot say that I saw him, so I don't.
Well, did you ever see any in the closet?
I didn't see.
Oral.
I didn't see anything on his closet.
So you don't know whether he owns any or not?
Oral.
Do you know whether or not the defendant owns?
I don't recall if he has some or not.
He might have some.
I don't know.
Sustain. Sustain, but the answer will stand, I don't know. The answer was I don't know, so the answer will stand.
Now, you still work at 360 North Rockingham?
Yes, I do.
You still work for the defendant?
Yes, I do.
And his family is staying there now?
Yes.
Okay. You watch the trial on television sometimes?
I only watch the trial when his family is on the
Witness stand?
witness stand.
Okay. And have you spoken to any member of his family about your testimony?
No.
Now, you saw a photograph, People's 167, a few minutes ago. You remember that photograph?
Yes, I do.
You saw straps on the bed?
There's something on the bed.
Okay. Did you notice what was on the bed?
Can I see it, please?
Straps.
I have a copy of 167. Can I approach?
Yes.
Okay.
Those are straps, right, on the bed? Suspenders?
I don't know if this is a suspender or strap from the bag. It look like. You cannot say if this is a suspender or a strap from a bag
Okay,
because there is some wordings that you can read, like Louis Vuitton, something like that.
Okay, well, how many different straps or suspenders or straps on the bed do you see on the bed?
This is, I think, one. It look like only one.
Okay, well, do you see something that's brown and something else that's black?
I think, yeah, there's like a black something. I don't know.
Okay. Now, Mr. Simpson wears suspenders with his tuxedo, doesn't he?
I don't know.
He owns suspenders, doesn't he?
I usually only see the belt, but I did not see him wearing a suspender.
Okay. You don't know whether he owns a pair of suspenders or not?
Oral.
Is that correct?
Can you repeat the question,
You don't
please?
know whether or not he owns a pair of suspenders?
I didn't see some of it on his closet, so I don't know if he owns some.
Are you aware that the defendant wore a tuxedo to an event that Saturday night?
I'm not there, so I cannot say that he's wearing a tuxedo or not.
Okay, and you've told us that it would be unusual for the defendant to leave any of his clothing out. Is that right?
Yes, he put everything back where he got it.
And so if he left his suspenders out on Saturday night, that would be unusual, wouldn't it?
Sustain. Sustain.
When was the last time prior to June 12 that you cleaned the house?
Almost every day.
From top to-
Friday,
You cleaned the house Friday?
yes.
You clean every room in the house Friday?
I have a sequence of cleaning the house. One day I will clean the family room, portion of the house, portion by portion, because I cannot do everything on one day. So there's a day that I will do sequence things so that I know everything is clean.
Okay. And Mr. Simpson's a very meticulous man, isn't he?
Yes, but on his bedroom, I need to do it every day when he's in town.
All right. And so, can I have one moment, Your Honor?
Yes.
So did you also clean his bathroom every day?
Yes,
Okay.
when he's in town, I need to do it every day.
And you clean that on Friday, is that correct?
Yes, I do.
And so had there been blood on the floor of the defendant's bathroom that Friday, you would have cleaned that up, correct?
I usually clean his bathroom, so I will clean it.
Okay. You wouldn't leave blood stains on the bathroom floor, would you?
I never see blood stains, so I don't know how to answer that question because I always clean the bathroom.
There were no blood stains on the floor when you left that Friday, is that correct?
Sustained is vague. Vague is the location.
I'm sorry?
Vague is the location.
Okay. There were no blood stains on the bathroom floor when you left that Friday, is that correct?
Overruled.
Yes, there's
What time did you leave the house on Friday?
approximately 9:30 or 10 that night.
9:30 or 10 that night?
Yes,
And was the defendant at home when you left?
yes, he is.
Okay. And did you return to the house Saturday?
No, I did not.
Did you return to the house on Sunday?
No, I did not.
So if there was blood on the master bathroom floor on Monday morning, you can't tell us how that blood got there, correct? Monday?
Monday morning. Monday morning. Overruled.
Can you
Okay.
question, please?
Okay. You can't tell us how the blood that was discovered Monday morning was found there, is that correct? This is item 14, Your Honor.
Proceed.
You can't tell us how the blood that was found on that bathroom floor on Monday morning got there, can you?
No, I did not.
You weren't bleeding, were you?
I'm not.
You weren't bleeding that Friday, correct?
No, I'm not.
Now, prior to leaving, strike that. Is there some reason that you leave so late or left so late that Friday night?
Because Mr. Simpson that Friday just got back from a trip. That Friday. So I need to prepare dinner for him before I will leave and leave the house clean before I go to take my day off because,
Okay. So you make sure everything was clean.
yes,
You make sure all the laundry was done and folded.
yes.
You wouldn't leave for the weekend and leave wet laundry in the washing machine, would you?
No, I will not.
Let me show you a video, just a small portion.
Which exhibit are we talking about, counsel?
A small portion of 1068, Your Honor. Of the laundry, of the washing machine scene. Same video we've been looking at all day.
Mr. Wooden, do you have that queued up? All right. All right, this is part of Mr. Ford's videotape. All right, proceed.
Let me just show you a small portion of this video.
Nothing wrong.
Yes, please look at the monitor. This is 3:01 p.m. on the tape. Okay, stop there. Okay, you didn't leave that in the washing machine, did you?
No, I did not.
Okay. Did you notice what the clothing items were in there?
It's not here now, so
You want to see it again?
yes.
Okay. Inside and on the top.
Okay.
Okay. There's a pair of panties in there. Is that right?
That basket that on the top of the laundry,
Yes.
that's belong to Arnell.
Okay.
Maybe Arnell did some laundry before after I left because that basket belonged to her. So maybe that's her clothes.
Okay. That basket wasn't there when you left?
No.
Okay. Good. Now, you told us that the defendant was always rushing around. Is that right?
Yes, he is.
And so, and you also told us that whenever he rushed around, he also put everything in place before leaving.
Yes.
So is it your testimony that he would risk missing an airplane to put his bedroom back in order?
He went.
Phrase the question.
Okay. Would the defendant risk missing a plane so that he could put his bedroom back in order?
Sustained. Phrase the question.
Okay. If you know, has the defendant ever missed an airplane because he was at home placing his bedroom back in order?
Overruled.
I don't know that he missed any airplane.
You take that off. And you told us how you cleaned the house on Friday. Let me ask you this. Had there been blood in the foyer? You know what you know where the foyer is in there?
Yes.
Okay, I'm sorry. Had there been blood there on the floor in the foyer, you'd have cleaned that up, correct?
Yes.
And you cleaned that area Friday, didn't you?
Prior to that, I did not clean it on Friday, but I cleaned the foyer area on that week.
Okay, and you didn't see any blood at that time, did you?
No, I did not.
Had there been blood there, you'd have cleaned that blood up, correct?
If there is, I will clean it, but I didn't see anything.
Okay. And you didn't see any blood when you left around 9 or 9:30 that Friday night, is that correct?
Yes.
Now, what's people's next in order?
535. 535.
I have a photograph, two photographs. I'd like to mark one 536 and one 535, and I will show these to Mr. Cochran. I don't want to approach Judge. I'm ready to go.
Are we asking to approach? All right. Why don't you show it to the witness first, see if you can lay a foundation for it.
Let me show you the photograph. It's been marked equals 536. There's a photograph depicting the photograph. Do you recognize the two people shown in the photograph?
Yes, I do.
Okay. One of those people is Nicole Brown,
Yes.
the defendant.
Yes.
And is that a, I'm sorry, man. Let's strike that. That's the photograph you've seen before?
I never see this photograph. No.
You've never seen that photograph before?
Overruled.
Well, whenever you would do cleaning, you would clean this entire room, correct?
Yo, every single question Johnny asks, he repeats. Do you see this photograph? Yep. You're looking at this photograph? Yep. Okay, so you see this photograph? Yep. He repeats every question, and Darden just did it once. Yeah, objection. Asked and answered. How dare Darden do that? Judge, get him. Give him sanctions, judge.
Yes.
You clean up those things I have in my room called dust bunnies. You make sure there wasn't a lot of dust and stuff around.
It's not surprising, but it's irrelevant. Mr. Darden.
I'm a bachelor, Your Honor. You'd make sure that there wasn't an excessive amount of dust in the bedroom, correct?
Yes.
Okay. You look underneath the bed and make sure everything was clean, right?
Overruled.
Your Honor,
Proceed.
you clean underneath the bed, right?
I never clean underneath the bed. Never clean.
You never ever cleaned underneath the bed?
I'll just vacuum the side of the bed, but I will not look and clean what's under the bed.
You never look underneath the bed to see if the defendant's shoes were perhaps underneath the bed?
No, because I know his habit. He will put everything in place, and he never leaves his shoes or whatsoever under the bed. So
Well-
I will not look anything under the bed.
Do you recognize this photograph, 536, as showing a portion of the defendant's bed?
I did not. I don't know that picture. I didn't see it.
I'm talking about the bed part of it.
Yeah, I saw the bed.
All right, that's the defendant's bed.
Yes.
Okay. Can I show the picture?
Not at this point.
Well, during the time that you would vacuum around the edge of the bed, did you ever locate a picture of Nicole on
No.
the floor?
I did not.
Did you ever locate a picture of the defendant and Nicole on the floor around the bed?
No, I did not. I didn't see any
All right,
picture.
counsel, let me see you without the report.
Sir, if you ask her about under the bed one more time, Ito is going to drop kick you.
That Friday night, did you leave by walking down the Rockingham driveway?
No,
Where was your car parked that night?
at Asford.
On Ashford on the street?
Yes.
It wasn't parked up against the garage door?
Against the garage? No.
Okay. In Ashford, that's where the defendant usually parked the Bronco, is that correct?
It's a big,
Pardon?
yeah, he usually park his car there.
Okay. When you left Friday night, the defendant's Bronco wasn't parked on Rockingham, was it?
I didn't see it in Rockingham.
But he was home when you left, correct?
Yes, he is home.
Do you know where the defendant buys his socks?
What?
Where does-
Excuse me?
Where does Mr. Simpson buy his socks?
I don't know. I don't ask him where he buy his socks.
Okay. Now, you say you spoke to the defendant that Sunday night at 8 p.m.?
Yes, I did.
Oh, by the way, you told us that the defendant went to Palm Springs on Memorial Day. Is that correct?
Yes.
And he didn't go there with Paula Barbieri. He went there to meet her. Is that correct?
I don't know. But I know they are together on Memorial Weekend. But I don't know if he drive by himself or he will meet Paula there. All I know they are together.
Okay. Well, do you know whether or not he and Paula Barbieri had a big fight in Palm Springs?
Sustained. Sustained.
Well, did you have a habit of discussing with the defendant his personal relationships?
Overruled.
Discussing his relationship, no.
Okay. So you wouldn't know.
Overruled. She's indicated she didn't discuss his personal relationships.
Did you know the defendant in 1989?
No.
Did you know him in October of 1993?
No.
Let's have a few more questions, Your Honor. One moment. As part of keeping the house clean, you would clean all the pictures, right? You dust the pictures off?
Sometimes if they need to be done, I will do that.
Okay. Now, you understand that the jury had a jury view of 360 North Rockingham, is that correct?
Yes, I do. I'm there.
Now, you made some additions or some changes.
Sustained.
Is that due to foundation, or
I'm going to sustain the objection at this point.
is that to any questions regarding the jury view and purpose? Should I come up and...
With the court reporter.
Yes.
And you did most of the talking during that conversation?
Yes.
Okay, and that's because you were the one making the request, is that correct?
Yes.
Okay, so you didn't have a lot of time to assess his demeanor over the telephone, correct?
Overruled.
Is that correct?
Can you repeat the question,
You
please?
didn't have a lot of time to assess his demeanor while you were talking to him over the telephone, correct?
I know that he's the same way that I usually talk to. So even it's a short time or long time, he's the same person that I usually talk to.
Okay, so he sounded like the same person that you
Yes.
usually talk to? But obviously you couldn't see his facial expression at the time, right?
Overruled.
Right?
You cannot see his face expression, but you can hear how he talk.
And obviously you didn't know what he was thinking at the time, correct?
Sustained. Sustained.
When you returned to Rockingham the next morning around 10 o'clock, you weren't allowed to go onto the property, is that correct?
Yes.
But you were allowed to stand out front, is that right?
In front of the property, no. The police officer told me right away that I cannot get in. I said, why? Because I see the...
Okay, so you went. Is that okay?
Proceed.
Okay. Right. So you didn't see the police when they recovered items from the back of the house?
Overruled.
Excuse
Did you see the police recover an item of evidence behind the house?
recover item of evidence inside...
Overall.
Excuse me. Can you
Yes.
repeat the question?
Did you see the police recover an item of evidence from behind the house?
I saw some actions in and out of the house. There's some people coming in and out, and I saw a big van outside the property.
Just one last question, or two. With regard to the defendant's bed, did he leave his bed unmade when he got out of it?
He will.
Is that
He will.
right?
Unmade, yes.
Okay. He would leave it unmade so that you could make it. Is that right?
Yes.
And is that what you normally did?
Yes.
And would he? Strike that. And after taking a shower, would he always hang up the towel on the rack?
Yes.
He wouldn't leave a towel laying around on the edge of the bathtub, would he?
No.
He wouldn't leave a towel on the floor, would he?
No.
That wouldn't be normal for him, would it?
He will hang it on the door of the shower room.
Now, when you talked to the defendant on the phone that night, he didn't complain to you about his arthritis, did he?
On June 12th?
Yes.
No.
He didn't tell you that he was in pain, did he?
No, he did not.
I'd rather just end. By the way, did you ever go behind the house? That is behind Arnell's room and Cato's room?
I go sometimes.
Yeah. You go back there sometimes?
Yes.
Is there an air conditioning unit back there?
Yes.
Now, if you follow the pathway behind the house, does it lead to an area where there's dirt and grass and stuff?
Sustained.
That's all. Thank you.
Mr. Cochran, anything more?
Yes, very.
Proceed.
Just a few questions on that, Your Honor. With regard to this card that Mr. Darden showed you, the field interrogation card, you answered just the questions the police officer asked you, isn't that correct?
Yes, I do.
And you told this police officer the truth, is that correct?
Yes, I do.
And if the police officer had asked you if you were at Knott's Berry Farm or where you were, you would have told him, right?
I will tell them where I am.
All right. If the police officer had asked you if you asked permission to stay out, not come home that night, you would have told him that, right?
Yes.
It is.
But
Mr. Gordon, keep your voice down, would you please?
now, with regard to the clothes that were in the hamper, I saw some. Excuse me, Your Honor. I saw some panties.
Overruled.
I saw some panties in and around the washing machine. Mr. Simpson never wore any panties around that house, did he?
No.
And you know that those clothes in that hamper, that was Arnell's clothes, isn't that
Yes,
correct?
they are.
And Arnell would wash her clothes inside the house there, isn't that correct?
Yes.
And would Cato Kalin also wash his clothes in the house also?
Yes.
Now, does Mr. Simpson shave every day, as far as you know?
I think yes.
Now, with regard to, you were asked some questions about cleaning the house, and I believe you indicated to Mr. Darden that you had kind of a routine and you clean various parts of the house on various days in the week. Is that correct?
Yes.
With regard to the foyer area of the Rockingham residence, do you recall on what days of the week that you cleaned that foyer area prior to the time you left on Friday, June the 10th?
I mop it maybe around Tuesday or Wednesday.
All right. Tuesday, Wednesday, early in the week?
Yes, early in the week.
All right. And you had not cleaned that area after that, is that correct?
I just sweep it, not mopping it.
All right. Now, on Friday night, you said that Mr. Simpson had come back home from out of town,
Yes, yes,
and you stayed there to prepare dinner.
yes,
And did he have a guest there that night?
yes.
Who was that guest?
Paula?
Paula Barberi?
Yes, Paula Barbier.
Did they have dinner that night?
Yes.
Were they still there together when you left?
Paula need to leave because she is going to attend like a prayer meeting, something like that.
What kind of meeting?
Prayer meeting?
Prayer?
Yes.
Prayer, like as in prayer?
Yes.
Okay. She's leaving for a prayer meeting?
Yes.
We have an interpreter in the jury here. Proceed.
Well, thank you. So, what, excuse me, Your Honor. What time did Paula leave for this prayer meeting?
Before I,
What time did Paula leave for the prayer meeting?
It's irrelevant, really.
Well, no, I want to know from a standpoint of sequence, Your Honor.
All right.
Thank
What
you,
time did
Your
she
Honor.
leave?
I'll let you know.
before I left that night.
So you left at 9:30, and Paula had left for the prayer meeting before that?
Yes.
Is that right?
Yes, after dinner.
Okay. Now, with regard to your room, premises there, your room is downstairs, is that correct?
Objection, this exceeds the scope.
Well, I have just one or two questions just in this area. Thank you. Your room is downstairs, is that correct?
Yes.
And, Ms. Gurn, is there a door to the side of the house right near your room?
Yes, in between the laundry room and my room.
And can you come in on that side of the house if you have a key and get in that door?
Yes.
And what kind of key is needed to get in that door?
Master key.
And how many master keys were there in June of 1994?
There's only 2.
And who had those master keys?
I have 1 and Mr. Simpson have 1.
If you had a master key, you could come inside that door, is that right?
Yes.
Did you ever have occasion to talk with West Tech at all on when you were going to be off and Mr. Simpson would be out of town?
I didn't.
It does. Sustain.
Thank you, Your Honor. I think that's all I have at this point, Your Honor. Thank you very much.
Anything else, Mr. Darden?
Let's go back to cleaning habit for one moment. Had you seen a spill or spot on the floor, you'd have cleaned that up, right?
Yes, I will.
Okay. That's all. Thank you.
All right, Ms. Guerin, thank you very much. You're excused.
You're welcome.
All right, let's take our mid-afternoon break at this point. Ladies and gentlemen, Please, oh, Ms. Kern, you're excused. Thank you. All right, remember all my admonitions to you. We'll take about 15, okay? All right, let's have the jury, please. Oh, I'm sorry. All right, Mr. Scheck.
Yes, Your Honor. I have a motion in limine with respect to Detective Moldorfer's testimony. We intend to call her for a very limited purpose, and that is to establish that she was conducting an investigation of a possible violation of OPG rules, that during the course of her investigation, she determined that there was a system for logging who goes in and out the area where the Bronco was being held, that information came to her attention that several detectives and officers had been in and out, but were not logged in. She went to, she could not ascertain who those individuals were. She did ascertain that an SID person, Mr. Fung, had gone in and out. She then had a conversation with Mr. Fung concerning the times he went in and out.
That is not logged.
I'm sorry?
That is not in the log?
Yeah, there was no log of who went in and out. That's the point that I want to establish from her, that she had a report that certain officers and detectives came in and out. She couldn't ascertain who those were. The only person she asked was Detective Van Adder. And that she did ascertain that Mr. Fung had been in and out, and that she asked Mr. Fung what he did, and then he gave a statement to her that on July 6th he went to the Bronco, looked at it to refresh his memory for court, and did not remove anything from it, which was a prior inconsistent statement that I'm seeking to introduce in terms of Mr. Fung's testimony.
What did he testify to?
Mr. Fung testified that on July 6th he went to the Bronco at the request of Ms. Clark for purposes of seeing whether or not there were stains on the door sill of the Bronco, that and he then performed a presumptive test. I'm sure you don't forget that, because that got us into some trouble on that ruling. And he testified that he performed a presumptive test on a stain from that Bronco at that time. And I asked him specifically...
All right, and what did he say that's inconsistent to Detective Moldorfer?
Well, what he said to Detective Moldorfer is that he went there just to refresh his memory for court, and he didn't remove anything from the vehicle. And I asked him in the course of questioning whether he removed anything for purposes of performing the presumptive test, which of course he had to do, and he said yes. So those are the points.
So in other words, all you want to get from Detective Moldorfer is A, she conducted an investigation as far as the security there and determined that there was no system for logging in officers in and out.
They had a system, but they didn't follow it. That was her conclusion. And
right.
that there were
And
various
then
people in and out of there. She couldn't run down. She ran down Fung. She spoke to Fung.
But how did she determine there are various people who came in and out?
She had a report. She got information from Mr. Jones, who had brought her in, that, to quote her report, that several people, officers and detectives, had been in and out, but they hadn't been logged in. She attempted to find out who those individuals were, and the only person that she inquired about that to, she tells me, is Detective Van Adder, and that was it.
All right, I'll hear from the people.
And the point of this ruling is that I'm not going into anything about Mr. Mraz and what he said and the reasons that the city attorney did have or didn't have for bringing us a complaint against Mr. Mraz and all that stuff that's been gone into. If they choose to bring it on the rebuttal case, but that's not the purpose of bringing her here.
Mr. Darden?
Well, we have a couple of objections, Your Honor. First of all, as to anything that Mr. Jones may have told Detective Moldorfer, that's hearsay. That's hearsay, and it's being offered for the truth of the matter stated. Counsel was offering that hearsay statement to establish that there were multiple persons that went in and out of the Bronco. That's hearsay. And Detective Moldorfer did attempt to run that down, and she determined that that was not true. And she also determined, I believe, that Bob Jones had no basis in fact for making that statement as well. In any event, that's clearly hearsay. We object to that, and he shouldn't be allowed to go into it. As far as the impeachment of Dennis Fung is concerned, Dennis Fung did not tell Detective Moldorfer that he just went to the Bronco on July 6th to refresh his recollection. That's not what he said. He said he went there to refresh his memory for court, but he didn't say that that was the only reason. He never said that was the only reason. This is not, that statement is not inherently inconsistent with what Dennis Fung stated here on the witness stand. In addition, on the issue of whether or not Mr. Fung removed anything from the Bronco on July 6th, we agreed that he told Moldorfer that he did not remove anything on July 6th, but he also told the jury that he did not. He told the jury that he only did a presumptive test, that he did not take any samples, that he did not remove any physical evidence. That is not inconsistent. There was no inconsistency there, and counsel should be precluded from dragging that hearsay into the case. As far as the issue of the reasons for the
Be
investigation...
careful, you're going to get sanctions.
Counsel's going to ask the witness if she conducted an investigation of possible violations of OPG rules. Well, I think I have a right to go into what those violations were. What triggered that investigation? And what triggered that investigation is Mr. Mraz, an employee, a thief, and someone who admitted to having lied when confronted with having removed things from the defendant's Bronco. We should be allowed to go into that. They can't just ask these questions and then expect us not to go into the issues, to develop the issues, and allow the jury to.
Let's assume that you asked the question then on cross-examination, what was the genesis of the investigation? It was the allegation that one of the employees, a John Mraz, removed items from the Bronco automobile. Is that correct? Is that what the question and answer is likely to be? And doesn't that pretty much cover it?
It's cross-examination, Your Honor.
Doesn't that pretty much cover what's
Well,
relevant?
I don't think it pretty much covers it at all, because I think we have to get
Well,
down to specific issues, and how they relate to.
Theft of items from a car that's supposed to be held in some type of security. That's pretty clear, isn't it?
Yeah, that's clear to me.
All right.
But can I
Two
indicate-
questions.
And can I interject this as well? Why is this even relevant? Why is it this detective's investigation, days, many days, well beyond July 6th, let alone June 13 or June 14? Why is this even relevant? Why are we wasting our time on this? This doesn't prove or disprove or establish any material fact that this jury needs to have before it to
The whole
determine his
point
guilt.
that Mr. Scheck is trying to establish is that multiple persons and persons unknown had access to the Bronco, and that it was in an unlocked state for a significant period of time. I think that's the point.
It's all hearsay, Your Honor. Moldorfer wasn't there. She doesn't work there. The only way she would know that is if someone told her. And in fact, I don't think Mr. Scheck knows that. And what he's going to do is interject that notion into this trial by innuendo. There's no proof of that multiple persons accessed that Bronco. That is beyond what Mr. Mraz has already told us.
All right. Well, but you concede. I'm assuming you're not conceding the inconsistency of any statement by Mr. Fung. But if it were an inconsistent statement, then Detective Moldorfer, you'll concede, is competent to testify to any statements by Mr. Fung to her.
Yeah. If the court finds him inconsistent, yes,
All right.
with his testimony. And if she's
right.
going to testify to anything, that ought to be it.
Mr. Scheck.
Yes,
What concerns me about Mr. Darden's argument is that Detective Moldorfer's opinions are based upon statements from other persons. And
Well-
is she competent to testify as to who had access to that
well, I don't
Bronco?
think,
Wouldn't it be Bob Jones?
well, it seems to me, Your Honor, that what she ascertained during the course of her investigation is that they had a system for logging in names, but that system was not implemented. It's
Then by
something
that,
that's
if I
required.
use that analogy, though, then Detective Lang is able to give his opinion as to who committed this homicide.
Oh, no, I think that this is simply an investigation. She's going to testify that they ought to have a system in place. They had a system in
trade?
place. No, they
Yeah,
ought to have
well,
had a system
I'm
in place.
concerned about the competence to testify that other people had access.
No, then it's by inference. The point is that she was able to ascertain that there is a system of logging that is there to be followed, and it was not followed in this instance. Mr. Fung was not even logged in on this system, and there's no dispute that he went to the vehicle twice during the course of this. And my point is simply, following up what the court indicated, is I want to establish what the rules and procedures are for storage of these vehicles, what systems were in place, what systems were not followed in terms of logging people in and out, to establish access of several people, or possibly a multiplicity of people, and that she had information that there were other people besides Fung. It was her responsibility to try to track them down, and she could not. I mean, he's free to establish by asking her, who did you make inquiry with, to try to find out who these people were, and are you satisfied that you've established it was no one? I don't object to him going into that in terms of the scope of the direct. My concern is, I don't even mind him asking her whether she was there as one or two questions, as the court indicates, as part of her investigation. She was investigating a few things. The rules, were the rules followed for storing the vehicle properly, and as part of that, whether or not a permittee, Mr. Mraz, had violated a rule by committing a theft. That was all part of this
He's not a
investigation.
permittee. He's an agent of the permittee.
Good. She told me something. I'm only going on what she said. But my point is simply this. I'm not going into the whole investigation of Mraz and
All
everything
right, but
else.
let's get back
That's
to
my
more,
concern.
Let's get back to the more fundamental question, though. She is an investigator who
Yes.
interviewed witnesses. So you're saying that she should be able to come in and give us opinions based upon hearsay.
I think she's competent to come in, and it's non-hearsay testimony for her to establish, A, what the rules are, B, what systems were in
All right,
place.
let's assume she's an expert in the area of OPG garages, so she can testify to the rules and regulations that are required. I take that as I accept that. But whether or not those rules were followed, she only knows that on the basis of talking to other people, nothing that she witnessed or is competent to testify herself to.
Well, I don't think that Fung wasn't recorded in. We know that the log of people, she was able to ascertain that no log was kept.
Do you have the log?
There was no log. That's the point.
All right, that's something she can testify to. Did
That's
she
right.
go there? Did she ask to see the log? Was a log produced? There was no log.
That's right.
Is that a violation of the OPG procedure? Yes, it is. Thank you very much. Goodbye.
Well, and the final thing, and the additional point, is, did you ascertain whether or not there were individuals who did go to that vehicle who were not logged in, or there was information? Did you attempt to investigate that?
Well, if there's no log, how can she possibly ascertain that?
Wait.
other than-
I'm discussing this with Mr. Scheck.
I'm only trying to get from her what she heard and what she did, in terms of trying to, and I think it's
You got it.
admissible for the fact that it was said. No, she was told that officers and detectives were seen going in and out of the vehicle. She then conducted an investigation to determine who. He's free to bring out what she did and didn't do. She went to Detective Van Adder. She spoke with him. As far as I understand, that's all she did. And that's
All right.
it came to her attention that there were unaccounted for people, which is a violation of the rules. That's within the purview of her investigation.
All right, you're going one leap too far here. You can put in that she's in charge of investigating OPG garages. She can testify to the rules and regulations. She can testify that she went to Vertel's to see what the logging process was. It's your representation that she's going to testify that there was no logging system in place,
There was one in place, but it wasn't followed. In other words, there was nothing recorded on the logs.
that she examined the logs.
Well, I'll have to ask her that specifically, but I'm going on a report on what you just told me.
All right, did we subpoena the log? Wait, Mr. Darden, please, I'm going to...
This will go the question.
No, this will go a lot quicker if I get to talk to one person at a time. Do you have the log?
I don't believe we have a log. I don't know whether there was a log or not. She indicated there was no logs in, one way or the other.
No logs, period.
No.
She will say there is no log.
She testified to an absence of the record. I can ascertain that. If we can bring her in.
Let's bring her in. No, wait a minute.
The last question I intend to ask her is, was she in the Bronco? Did she look in the console area, and did she notice any blood?
Personal knowledge, not a problem.
Right.
All right, Detective Moldorfer is here. Spot 4, Detective. All right, Mr. Scheck, you want to ask Detective Moldorfer what she had?
Now that's an outfit. I can almost smell that outfit. In the 90s, it would be like Gina Tay or Obsession. I'm going with Gina Tay.
Detective Moldorfer informs me that they have forms for logging people in. There's a system set up if they were to use it, but she ascertained that they didn't use it and they didn't log anybody in.
How is this record kept? Is it a loose leaf notebook or what?
They have I believe they just have similar to that, or a clipboard with a paper with lines for the names and divisions, just real basic information. There was no log. That is the way they teach it. There was no log.
There's a form, so there's a form but not a log. There's a form for
And none were kept at the relevant time in question, or for a specific time period. Because I assume that once this was brought to their attention, they started a log.
Yes.
At what point, Detective? At what point did they start complying with the log requirements?
On August 29th is the first entry of their log that they now keep. August 29th, 1994.
So, to your knowledge, there's no log entries between June 14, 15th, and August 29.
I just asked them if they had anything logged in for that vehicle, or if they logged in any of the people that went in to look at the vehicle, and they said no, they didn't log anyone in relative to that vehicle.
And who told you that?
Mr. Jones.
All right. Detective, why don't you go ahead and have a seat? All right, Mr. Scheck, do you have any other comment?
No, I'm just seeking the court's guidance on whether they can go into.
Mr. Scheck, I think you can establish the point that no log was kept, but I don't think Detective Moldorfer is the person who's going to be able to do that for you.
Well,
Because the basis of her information is what Bob Jones told her. That's hearsay.
then we'll take it a step at a time.
I'm
In other
sorry?
words, we'll take it a step and a witness at a time. I can certainly establish that she had a conversation without telling us the content with respect to who went in and out. No, not the
No,
conduct.
that she conducted an investigation as to who had access to the Bronco. Sure, she can tell us that. That's the whole reason she's here. All right. As far as Detective Muldorfer is concerned, then, what I will allow is who she is, what she does, what her responsibilities were regarding OPG garages, that there are rules and regulations that govern OPG garages, which includes keeping a log, and that she conducted an investigation over at Vertel's. I think the prosecution is entitled to bring out the fact that this investigation, the genesis of this, was John Mraz and that situation, and that during the course of this investigation, it's your representation that she actually looked in the Bronco.
Yes.
All right, she can testify to what she saw or did not see there, and she can testify as to who she interviewed with regards to the procedures, and she can testify to the statement by Mr. Funk.
She can't testify to the conclusions.
No,
Okay.
that's hearsay. What somebody else told her about the log is hearsay.
Okay.
And if she
And what-
didn't see the log and examine it herself, but Bob Jones is the person who has to come in and say that this log was kept in this manner or not kept in this manner, depending on what the answer might be.
Okay, how about the fact that she saw a criminal filing?
That's neither here nor there at this point. Because then we're going to have to drag in the city attorney to tell us why they didn't charge Mr. Mraz. And that's,
Yeah, I mean, just the fact that she recommended a filing. We handle that in 2 questions.
I don't intend to bring it out. If they think that's relevant, they can bring it out in the rebuttal case. That is extremely complicated and I think unfairly prejudicial. I have no
well,
intent-
I will see, let's see how it goes in the context of what's elicited on direct.
Well, that's the whole reason for bringing this motion, because I don't want to go into all of that. I think it's a diversion from...
I don't want to go into it either. I just told you what I'm going to allow.
Okay.
All right? But they are entitled to ask a few questions. What was the reason you were there to conduct this investigation,
Absolutely.
period?
No problem.
All right. Let's go.
Could she be declared an adverse witness?
Why?
Well,
I think it's
So I can-
premature
all right.
at this point.
My name is Kelly Muldorfer. That's Kelly Muldorfer.
Mr. Scheck.
Detective Muldorfer, what is your present position?
I'm a detective for the Los Angeles Police Department.
And where are you assigned now?
I'm currently assigned to Legal Affairs Division.
And in July of 1994, what was your assignment?
I was assigned to Commission Investigation Division, Enforcement Section.
And is that the what's known as the LA Police Commission?
Yes, it's part of the Police Commission.
And as part of your assignment at the LA Police Commission in July of 1994, did you have any jurisdictions over what are known as OPG official police garages?
Yes,
And were you assigned to conduct an investigation of at the Vertel's garage in July of 1994,
yes,
July 13th in particular?
July 13th.
And this investigation embraced the violation of OPG rules concerning storage of vehicles?
That was part of the investigation, yes.
And the other part of the investigation concerned an allegation of theft against Mr. Mraz.
Yes,
Orwell's foundational.
Now, are there rules, official rules governing how official police garages are supposed to store vehicles?
yes, there are.
And Your Honor, I'd like to put on the Elmo Defense 1253, the impound form.
Yes. Do you have a copy of that for Detective Muldorfer?
I think she has one with her.
Do you recognize the document?
Yes.
All right. Mr.
Now,
Scheck.
I'd like to go up to the upper left-hand corner to the box that's entitled Give Special Care. Now, that box entitled Give Special Care, what's the significance of that box?
That box is generally marked with an X or a check mark to let the garage know that it's supposed to be handled differently than the other cars.
All right, and is the term hold, the one that's used, hold for different purposes?
Yeah, well, a hold can be placed on the vehicle without it being an evidentiary hold.
And the significance of an evidentiary hold is what for purposes of subsequent action by the police department?
A vehicle that's held for evidence or given an evidentiary hold is placed into the evidentiary hold area of the official police garage that they're required to maintain.
All right, and is that because there are certain restrictions that are supposed to be placed on anyone going into that vehicle?
This is leading your objection.
Are there restrictions that are supposed to be placed by the official police garage on access to the vehicle if that box is checked off to give special care?
Same objection.
I'm sorry, could you
Sure.
ask that again?
Are there restrictions, are there rules that an official police garage is supposed to follow if the special care box is checked off?
Yes.
And what are those rules?
One rule is that it has to be placed into an area cordoned off from the other area. It has to be a covered area free from rain and wind and snow and things that might interfere with whatever evidence is in the car, on the car, like prints or something.
And that would include blood within the car?
Yes,
That would include trace evidence within the car?
yes.
What about access by people? What are the rules with respect to access by people if the give special care box is checked?
It limits the access to the to police and scientific investigation. The people that work at the tow yard should not enter that area or touch the vehicle in any way.
What about going inside the vehicle?
No, not unless they're directed by LAPD personnel to do so.
In terms of who is allowed into a vehicle if it's being held for evidentiary purposes, is there some kind of rules that are supposed to be followed with respect to making records of who can go in and out?
They're supposed to maintain a log of people that go into the vehicle and remove property or remove something from the vehicle. There should be a notation,
Well,
either on a log that they have generated themselves, or on the records for the vehicle. They have each vehicle has a card, and they also make notations on that card so they can go to it and see what went on with that vehicle.
All right, so either through the card or through a log, there's supposed to be some paperwork indicating who went into a vehicle that is being held for possible evidentiary purposes when the give special care box is checked.
Yes.
Now, when you were assigning investigation of Fertels, did you attempt to ascertain how many people had been in and out of Mr. Simpson's Bronco?
Yes.
Did you attempt to ascertain whether or not any records had been kept?
Yes.
Did you attempt to ascertain whether Vertels had a system in place which they could have used to record who went in and out of the Bronco?
Yes.
Did Vertels have such a system?
No.
No. In your report, did you indicate that they did have such a system?
They
Go ahead.
they
They call your
they had
attention?
they had the system by virtue of the ability to do it. In other words, they could have put that notation on the card. They could have kept a log. They do have a log that they keep for people that go into any vehicle and remove property. They didn't make any of those notations regarding this vehicle.
And in the course of your investigation, did you ascertain for the first time when a log began to be kept as to who would be going in and out of the Bronco?
On August 29, 1994, they began a more accurate log.
Well, prior to August 24th, you said, was there any
29th,
log?
August 29th.
August 29th, was there any log about who went in and out of that Bronco?
I was told that there was not.
Now, did you have a conversation, who is Bob Jones?
He's the general manager of Vertels.
All right. And without telling us what he said, did you have a conversation with him about the number of people
Objection, hearsay.
that might have gone in and out of the Bronco,
Yes.
based on his investigation?
Yes.
And did you attempt to ascertain how many people had gone in and out of the Bronco?
Yes.
And who else did you talk to besides Mr. Jones?
About who had gone in and out of the vehicle?
Yes.
I spoke to Detective Van Adder.
All right. And did there come a time when you conducted an interview with Dennis Fung about the Bronco?
Yes.
And did Mr. Fung tell you that he had gone to the Bronco on July 6th?
Yes.
And did you ascertain that there was no record of Mr. Fung going to the Bronco on July 6th?
Fertel's didn't have a record of that.
And did Mr. Fung tell you that the reason he went to the Bronco on July 6th was to refresh his memory for court?
Yes, I believe so.
He didn't tell you that he had been sent by Miss Clark.
Objection. Call for hearsay.
Sustained.
All right. Did Mr. Fung tell you
Same
that...
objection.
Different question. Did
And
Mr.
it's leading, Your Honor.
No.
Let's hear the question.
Did Mr. Fung tell you that he did not remove anything from the Bronco? Not a bloodstain or anything?
Objection.
He said he didn't remove anything that day.
Now, Ms. Moldorf, Detective Moldorfer, did there come a time when you yourself inspected the Bronco?
Yes.
And who were you with?
I was with Mr. Jones.
And do you recall which day this was?
No, I don't.
But it would be sometime...
I did get you one,
the,
but I drank it.
in the month of
Ha
July?
It was sometime between the time that I got the investigation, which would have been July 13th, and when they began their log.
All right. And when you went into the Bronco, did you inspect the side pocket panels on both the driver's side and the passenger side?
I looked into the side door panel, yes.
On the driver's side?
Both sides.
Both sides. And did you look in the direction and see the console?
Yes.
All right. And when you looked at the console, do you remember seeing any blood there?
I wasn't looking for that, so I don't recall if I did, and I don't recall if I didn't.
Well, when you looked at the console, do you remember seeing any blood there?
Objection. Ask the answer.
Overruled.
No, I don't have any specific recollection.
Darden?
Detective, are you telling us that there was no blood on the console?
No.
You weren't investigating the issue of whether or not there was blood on the console. Is that correct?
Yeah, that was not the focus of my investigation.
The focus of your investigation was Mr. Miraz, correct?
Yes.
You had learned that he had stolen some items from the defendant's vehicle, correct?
Yes.
And the items that you learned about were credit receipts. Is that right?
Yes.
Your investigation was focusing on the theft of items of paper.
Yes.
Your investigation wasn't focused on biological evidence, was it?
No.
You weren't investigating the issue of whether or not Dennis Fung tested the Bronco on July 6th for blood or bloodstains.
No.
As a matter of fact, you never asked him if he conducted a presumptive test for blood on the Bronco on July 6th, did you?
No, I never did.
You didn't ask Dennis Fung anything at all about any biological test he may have performed on the Bronco on July 6th, correct?
Correct.
Did you tell Dennis Fung what the focus of your investigation was?
Yes, I did.
You told him it was about the theft of paper?
I asked him specifically about the receipts.
And when you asked him if he'd taken anything from the Bronco, you were asking him if he'd taken any documents. Is that right?
Yes.
Overruled.
And that was the entire focus of your conversation with him. Is that right?
Yes.
And was that interview conducted over the telephone?
Yes, it was.
You called him?
Yes, I did.
Did you know Dennis Fung prior to that?
No.
And you identified yourself as a police officer?
Yes.
And he had to take your word for that, didn't he?
Yes.
You could have been a reporter for all he knew, right?
That's possible.
You don't know whether or not Dennis Fung was holding back on the information that he had. do you?
Sustained.
Did you attempt to ascertain whether or not Mr. Fung had been in the Bronco on June 14th?
June 14th?
Yes.
No, I never asked. I don't believe I asked him about that.
Okay. Your investigation focused on what happened to the Bronco after it arrived at hotels, correct?
Yes.
Okay. It didn't focus on anything having to do with the Bronco and what may have been done with it while it was at the print shed, right?
Yes, I specifically didn't touch on that area.
During your investigation, did you speak to Mr. Miraz?
Yes.
Your investigation didn't reveal any breach in security at the print shed.
No.
OPG rules require that vehicles marked special handling be kept in a certain area at Vertel's. Is that correct?
That's correct.
And the area has to be cordoned off,
Yes.
and the area has to be covered
Yes.
and free from rain and wind and snow.
Yes.
What date was it, if you recall, that you saw the Bronco at Vertel's?
I don't recall. It was very early in my investigation.
But you saw the vehicle inside a structure, is that right?
Yes.
And that structure was covered, wasn't it?
Yes.
That structure was cordoned off.
Yes, it was.
That structure was free from rain
Yes.
and wind
Yes.
and snow.
Yes.
That vehicle was being kept in a secured area, is that correct?
Fairly secure.
Well, it was secure from the public, correct?
Yes, it was.
Now, Mr. Miraz was an employee of Vertel's, is that right?
Yes.
And so what we're really talking about here is an issue of employee theft, aren't we?
Yes.
There's no OPG rule that would preclude Mr. Miraz from being inside that structure, is there?
No.
And when you saw the Bronco inside that shed, was it roped off?
Yes, it was.
When you looked inside the Bronco, you weren't looking for blood.
No.
You weren't looking for evidence that might connect the defendant to a murder.
No.
You were only looking to see if the credit slips that you had heard about were inside the Bronco, right?
That's correct.
And that was it.
That's it.
Now, you've told us that the impound form is not marked special handling, correct?
Correct.
If that vehicle had been delivered to Vertel's, had the vehicle been delivered to Vertel's and then placed in that secure area within an hour of its arrival at Vertel's, would that be in conformance with OPG rules?
Well, they can place it there themselves, or a phone call can have the vehicle placed there.
The main thing is that it is stored there, is that correct?
Yes.
And it was stored there.
Yes.
Thank you, that's all.
Mr. Scheck?
Detective Moldorfer, when you spoke to Mr. Fung, you told him you were a detective from the LA Police Commission.
Yes.
Was there any doubt in your mind that he didn't think you were a member of the press?
Sustained.
Did he answer your questions fully?
I was satisfied with his answers.
Did you inquire about a visit he had to the Bronco on an occasion other than July 6th?
I believe I asked him how many times he'd been to Vertel's and on what dates.
And did you get the details of what he did on those occasions?
Oh, well,
I asked him if, while he was at the vehicle, or in the vehicle, or whatever he was doing there, if he removed or noticed the paperwork that I was interested in.
Did you ascertain that on June 28th he removed a shovel and a towel in a plastic bag?
sustained.
What did you ascertain about June 28th? He opened up.
Sustained.
Did you attempt to find out the particulars of what he did on his visits to the vehicle?
No.
No.
No, I only asked him if, while he was at the vehicle or in the vehicle, if he noticed or removed any of the paperwork that I was interested in. That was the
Well,
crux of what I asked him.
in your investigation, did you not note down the details of precisely what he did on his searches or his visits to the vehicle?
Regarding the visit on the 28th where he removed the property, that information was gleaned from the property report
I'm
that I got from
sorry.
Detective Van Adder.
Someone else is going to have to answer John's question because I have absolutely no idea who this woman is. She has a clipboard with lines on it. That's all I know.
You mean you didn't ask him about what he removed on the 28th?
No,
You don't know?
The
No,
answer was no.
I asked him,
Excuse me, hold on.
Asked and answered.
Proceed.
Asked and answered. Asked and answered.
Yes?
No, there's no question pending, counsel.
I'm sorry?
There's no
Did you
question.
ask him what he removed on the 28th?
Overruled. You can answer that yes or no. Did you ask him?
not in that form, but yes, I did ask him.
Now, Mr. Darden asked you questions about the purpose of your investigation. Now, wasn't one of the purposes of your investigation to determine whether or not Vertels had adequate security for the holding of vehicles for purposes of evidentiary investigations?
Initially, that was one of the rules we were looking at.
And
That's what I
covered by
said, Josh.
Rule 14 and Rule
She has a
12.
clipboard with lines.
Board Rule 12, yes, having to do with evidentiary vehicles.
And you came to a conclusion,
Sustained.
all right? Did you recommend that Vertels be closed down because
Sustained. Sustained.
were, from your investigation of the measures taken to hold the vehicle at Vertels for purposes of evidentiary investigation, were their procedures adequate?
Sustained. No.
Mr. Darden asked you questions about protection that this vehicle had from rain and sleet and other environmental elements. You remember that?
Yes,
What about people? Are there not regulations in place to limit the number of people that can enter a vehicle that is being held for possible trace evidence investigation?
yes,
And would you not agree that one of the key protections when you're holding a vehicle for future criminalistic investigation is to keep a record of who goes into the vehicle?
it would be helpful.
It would be helpful, would it not, when trying to do subsequent tests on biological evidence recovered from such a vehicle?
Overruled.
I'm sorry, could you repeat?
Would it not be helpful to know exactly who had access to the vehicle if one is going to be conducting future criminalistic tests such as PCR DNA tests?
Overruled.
Well, I don't know what those tests involve, but it would have been helpful to me to know who had been in the vehicle.
And if one is conducting trace evidence investigations of a vehicle,
Overruled.
would it not be helpful to know what people might have been in it?
Well, I guess, again, I don't know what those tests are. I don't know what they involve.
It would be just fair to say that, from your point of view, in terms of conducting an investigation of the security system at Vertels, without knowing the details of these future tests, it's important to have records of who goes in and out.
Yes,
And you did the best you could with what you had to determine who went in and out.
yes,
But the only person that you were able to find out about was Mr. Fung.
yes,
But you did have conversations with others attempting to find out whether other people had access to that vehicle.
yes.
Thank you.
Mr. Darden?
Detective, you're not an expert in PCR,
No,
DNA,
no,
conducting investigations for trace evidence?
no,
You ever watched a blood stain?
never.
You have no expertise in any of these areas, do you?
No, I do not.
Detective, thank you very much. Next witness. Nope.
May we proceed, Your Honor?
Let's proceed.
Thank you. The defense will next call Detective Berluper.
Raise your right hand, please. You solemnly swear that the testimony you may give in the cause now being before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please have a seat. The witness stand and state and spell your first and last name for the record.
Yes, ma'am.
My first name is Adalberto, Adalberto. Last name is Luper, Luper.
Good afternoon, Detective Looper.
Good afternoon, sir.
Nice tie.
Thank you, sir.
Now, Detective Looper, you're a member of the Los Angeles Police Department, aren't you?
I am, yes, sir.
And how long have you been so employed, sir?
23 years, sir.
And you're presently assigned to the Robbery Homicide Division?
That's correct, yes, sir.
And Detective Looper, are you one of the investigators assigned to this case?
That's correct, yes, sir.
And when were you first assigned to this case?
I was assigned on January 13th, probably around 8 o'clock in the morning.
Was that January 13th or June 13th?
June 13th, I apologize.
Is that the June 13th of 1994?
That's correct, yes, sir.
And do you have you worked on this case basically since that time along with Detectives Lang, who's in court with us, and Van Adder?
Yes, sir.
All right, sir. I want to ask you just questions on 4 quick areas, and we'll be in and out, hopefully. We saw a video taken by Mr. Willie Ford earlier today in which a glove, apparently a brown glove, was on a table in the Simpson residence. Have you
Yes.
ever seen that?
Yes, I have, sir.
And can you tell the ladies and gentlemen of the jury how that brown glove got on that table?
That brown glove got on the table when, right after I had arrived, and Detective Van Adder had left the scene and left me in charge of the scene. Went upstairs, and during the course of my search of Mr. Simpson's bedroom and his master closet, the big walk-in closet, I located a singular glove that was located in the chest of drawers. I secured it and kept it with me, and it was inadvertently put on a stand downstairs, and I believe it was in the living room area.
So inadvertently, you put it on the table and was left there, is that correct?
That's correct, yes, sir.
And then Mr. Ford came along and just photographed it, is that right? Or videoed it?
Yes, sir, later on in the afternoon.
All right. And you've seen that, so we were talking about the same glove downstairs, right?
That's correct, yes, sir.
All right, sir. Now, in the course of your duties in this case, sir, and you told us about June 13th, you had occasion to search through Mr. Simpson's premises and at some point go into the bedroom, is that correct?
That's correct, yes, sir.
And did you at some point have occasion to go into the bathroom?
I did, yes, sir.
And in the bathroom area, did you have occasion to look inside a hamper that's located in Mr. Simpson's bathroom there?
I did, yes, sir.
And did you have occasion to take some clothes out of that hamper?
I did, yes, sir.
And did you have occasion to look at those clothes?
That's correct, yes, sir.
In fact, the clothes were taken out of the hamper and they were kind of like put on the bathtub area, is that correct?
Somewhere, yes, sir.
All right. They'd been in the hamper, and per your instructions, you had them taken out of the hamper, is that correct?
No, not per my instructions. I removed them myself.
Okay. So you removed the clothes yourself?
That's correct,
You
yes,
took
sir.
them and you looked through the hamper and took them all out, did you?
That's correct, yes, sir.
And after you took these clothes out of the hamper, you had some photographs taken of them?
That's correct, yes,
So
sir.
the photographs we've seen are of the clothes after they were taken out of the hamper, is that correct?
Yes, sir.
All right. Were any of those clothes that were in that hamper seized at all?
No, sir.
Did you have occasion to also look into Mr. Simpson's closet, the main closet off the bedroom?
That's correct, yes, sir.
And did you look through the clothes and Mr. Simpson's clothes that were located therein, did you?
Yes, sir.
And were any of those clothes seized at all?
No, sir.
Do you recall that at some point Detective Lang had a pair of tennis shoes, Reebok tennis shoes? Were you there when that happened?
No, sir, I was not.
So at least at the time that you left before Lang left, is that correct?
Yes, sir.
All right. And so what time did you leave that day? Do you recall?
I left around 6:30, 6:35 in the evening.
Before Detective Lang left?
Yes, sir.
All right. And at least when you left, you had not seized any of the clothes located inside the Simpson residence, right?
The only item that was seized in my direction were the socks, sir.
All right. Now, with regard, other than that, you hadn't seized anything else?
No, sir.
All right. You didn't seize any clothes taken out of the hamper?
That's correct,
You
sir.
didn't seize any clothes from the closet?
That's correct, sir.
And the brown glove that you had on the table that you'd inadvertently left on the table downstairs, did you do anything regarding the brown glove?
Yes, sir. That particular item, after a conversation I had with Detective Lang and Van Adder, was returned to the location I had recovered it from.
I know what you did was you took it back upstairs. Is that
That's
right?
correct, yes, sir.
Okay, sir. Now, what time did you arrive at the location that day, Detective?
It was about 12:10, 12:15 in the afternoon, sir.
Now, in connection with your investigation of this case, did you have occasion to go to Chicago, Illinois?
Yes, sir.
And when did you go to Chicago?
I went
Let me
June...
ask this. Did you go to Chicago on more than one occasion? Sorry.
Yes, sir.
Okay. Let's talk about the first time you went to Chicago.
All right. You want to know when I...
Yeah, when was that, sir?
I left, I believe it was June 15th, and returned June 17th in 1994.
All right. So you left on Wednesday and you came back around that Friday, is that correct?
Friday evening, yes, sir.
And were you accompanied by any other police officers, Los Angeles police officers when you went there?
My partner, Cliff LaFall.
Cliff LaFall?
Yeah, Lefall.
All right. And in the course of the time you spent in Chicago, you were investigating on this case also, were you not?
That's correct, yes, sir.
And on or about June 17th, did you have occasion to go to Chicago Police Department laboratory?
That's correct, yes, sir.
And did you at that point take custody of some items that were in the possession of the Chicago Police Department?
Yes, sir.
And among those items, did you take custody of a broken glass?
I did, yes, sir.
And did you take custody of some bedding?
Yes, sir.
Did you take custody of a towel?
Yes, sir.
Did you see some red spots on that towel? Yes. Red spots? You see red spots on the towel?
I never personally examined the items we recovered, no, sir.
Right. You've seen photographs of those items, have you?
I did, yes, sir.
And you've seen the items yourself, haven't you?
I have not seen the items at all other than the photographs, sir.
Now, in looking at the photographs, you saw that there was some red substance on the towels, did you not?
Sustained.
Well, now, with regard to these items that were picked up in Chicago, tell us what else you picked up in Chicago at that time relating to this case. Well, let's strike that. Let me ask you this. You picked up towels? Is that
Yes,
correct?
sir.
Picked up a broken glass?
That's correct, sir.
Picked up some bedding?
That's correct, sir.
And there have been photographs taken of those various items, have there?
That's correct, yes, sir.
And these items are all kept in a box now somewhere at SID or LAPD?
I believe so, yes, sir.
All right. Have you seen these items in the recent past at all?
No, sir.
When's the last time you saw those items that you brought back on June 17th?
Sustained. Rephrase the question.
Have you ever seen those items since you brought them back on June 17th?
Overruled.
No, sir, I have not.
Okay, well, tell us what you did. You picked them up at Chicago Police Department, the laboratory, right?
That's correct, yes, sir.
What'd you do with them at that point?
Hand carried them back to Los Angeles and booked them into the crime lab property room at Piper Tech.
The Piper Tech here at downtown Los Angeles?
That's correct, yes, sir.
And have you seen them since that time?
No, sir.
So what date did you book them into Piper Tech?
That would have been the 17th or the 18th of June of 1994.
After you got back here.
That's correct,
Is
yes,
that
sir.
correct? Any other items in that box you haven't told us about in our questioning here?
I believe you've covered most of the items, yes, sir. But as to specific items other than what you just mentioned, no, I don't have a recollection of.
All right. And those items, as far as you know today, are still over at Piper Tech?
I believe that Detective Lang picked them up for your purposes, I believe.
Well, he did bring them a couple of days ago for us to take a look at them.
I believe so, yes,
All
sir.
right. Are they still here, or are they back over there, do you know?
I believe they're still here, sir.
All right. May I have just a moment, Your Honor?
Bye, Terry, love. I can't believe you're leaving and missing this riveting court.
People?
Detective, what time did you say you arrived at 360 North Rockingham?
It was between 12:15, 12:20 in the afternoon.
Okay. And you met Detective Van Adder, is that correct?
That's correct, yes, sir.
And where were you when you met Detective Van Adder initially?
I believe I arrived prior to his arrival, and he arrived a few minutes later, and we met out by the front door, or right in the foyer. I don't recall exactly where.
You searched the house that afternoon, is that correct?
Yes, I did, sir.
Are you acquainted with Willie Ford, a photographer or videographer from SID?
I am, yes, sir.
Okay, you saw him there that afternoon, is that correct?
That's correct, yes, sir.
Did he arrive sometime after 3 o'clock?
Yes, sir.
You mentioned during your direct testimony that you saw some socks somewhere in the house.
I did, yes, sir.
Some socks that you caused to be seized?
Yes, sir, I did.
Did you see those socks before Mr. Ford arrived?
Yes, sir.
Do you recall what time of the day it was that you first saw those socks?
It was between 12:30 and 12:40 that afternoon.
You saw those socks when you went upstairs into the defendant's bedroom, is that right?
That's correct, yes, sir.
You told us that you opened a drawer and you recovered a glove, right?
That's correct, yes,
You
sir.
didn't have to open, I'm sorry. You didn't have to open a drawer to locate those socks, did you?
No, sir.
Where was those socks, Detective?
Those socks were located at the foot of the bed in plain view.
They were just laying there.
That's correct, yes, sir.
You sure of that, Detective?
Positive.
Why did you seize those socks?
Well, there's two reasons I seized them. One, they appeared to be out of place to me, based on what I had seen in the bathroom, for example. It was fairly neat. And the second was, I felt, based on the fact that they were out of place, that it would be just advisable to pick them up.
The bathroom was neat.
I'm sorry, sir?
You said the bathroom was relatively neat.
Relatively neat, yes, sir.
Let me show you 167 if you'll take a look at your monitor there.
All right, sir.
Is that where the socks were when you saw?
Yes, sir.
And when you first saw those socks, did you disturb them at all?
No, sir.
You left them right there.
That's correct, yes, sir.
Thank you. Now, when you first entered the residence, you saw some blood spots in the foyer. Is that correct?
I did, yes, sir.
And with regard to the glove, you conducted a search of the defendant's closet and master bedroom.
That's correct, yes, sir.
And where was it that you found that single glove?
It was located in, there was two chests of drawers located in Mr. Simpson's walk-in closet, and it would have been the one located against the east wall. I believe it would have been the south side of the master closet.
And you only found one such glove, is that right?
That's correct, yes, sir.
You didn't find a mate for that glove.
No, sir, I did not.
Okay, and you thought that was significant, didn't you?
Overruled.
I'm sorry.
You can ask the question.
Yes, I did feel it was significant.
And why is that?
Well, based on
Overruled.
based on the information I had, and the fact that the only information I had as far as gloves were concerned was one that had been recovered. I didn't know another one had been recovered. I just felt that it was a wise thing to seize it, hold on to it, and show it to the investigating officers, and let them make the final determination as to whether it should be booked or not.
A glove had been seized at Rockingham? Was that your information?
Yes, sir.
Had you visited the Bundy scene at that point?
I had been at the Bundy scene, yes, sir.
Okay. Had you reviewed the bodies?
Yes, sir.
Did you know whether or not the gloves seized at Bundy and the ones seized at Rockingham were matching gloves?
No, I had no clue.
Overruled.
I had no clue to that, sir.
Now, the glove that you removed from the defendant's chest, was that an heiress glove?
I don't believe so. It may have been, but I'm not too sure.
Okay. But it was a size large glove, wasn't it?
Yes, sir.
Not an extra large, but a large. Correct?
That's correct, yes, sir.
And you thought the glove was significant, so you kept it in your possession, right?
That's correct, yes, sir.
And then you went downstairs.
That's correct, yes, sir.
Why did you place that glove on the table?
Well, I knew that there was blood spots, or what appeared to be blood spots at in the foyer, and I was just trying to look for additional spots on the wood floor, and there appeared to be several trailing from the foyer and past to the den area. And in trying to examine them, I put my notebook down on the floor as well as the glove on the little table there to take a better look at it. That's all.
Okay. And that glove was videotaped by Mr. Ford as it lay on that table, correct?
That's correct, yes, sir.
And that glove was also photographed by the crime scene photographer Mike Wilson, correct?
That's correct, yes, sir.
And in fact, there was a crime scene photographer at Rockingham that day, right?
He was there when I arrived, yes, sir.
And so he was there at least 3.5 hours before Willie Ford arrived. Is that correct?
Minimum, yes, sir.
And the photograph you just saw here a few moments ago, People's 167, the photograph of the sock in the bedroom, that was taken by the photographer, wasn't it?
It certainly was, yes, sir.
Is there any question, any doubt in your mind, sir, that those socks were there when you walked up the stairs at around 12:15 or so that day?
No question in my mind, no, sir.
Matter of fact, you directed the photographer to take certain photographs, is that right?
I did, yes, sir.
And that included the photograph we just saw, 167.
Yes, sir.
Who requested the video recorder in Mr. Ford?
I'm sorry, sir, I didn't understand the question.
Well, did you ask Mr. Ford or someone to come out and videotape the premises?
One of the detectives, Detective Harper, who was at the scene, came to me and suggested.
Sustain. Question is, who requested?
Detective Harper did, sir.
And so you knew that someone was going to come out and videotape the premises, right?
That's correct, yes, sir.
And the purpose in having that person come out was not to assist in the crime scene investigation, was it?
That's correct, sir.
It wasn't to assist in the prosecution of this defendant or anyone else, correct?
That's correct, sir.
Why was that person called out?
He was called out in the event there was civil litigation down the line or allegations of theft or breakage of valuables.
You wanted to make sure that you documented the condition of the premises as it was when you left, is that right?
That's correct, yes, sir.
Did you direct Mr. Ford in terms of where to shoot or videotape?
No, sir, I did not.
Do you know whether or not the socks were collected prior to Mr. Ford's arrival inside the master bedroom?
They were collected prior to Mr. Ford's arrival upstairs and in my presence.
Do you recall who collected those socks?
It was Mr. Fung.
Now, you've testified regarding this issue before, is that correct?
At a motion, yes, sir.
You testified here in this courtroom on March 31, 1995. Is that right?
That's correct, yes, sir.
And Mr. Cochran was here?
Yes, sir, he was.
With regard to the items that you brought back from Chicago, you've never, we'll strike that, you obtained a box, is that right, from the Chicago Police Department?
No, no box. They were handed, when I signed for them, they were in bags.
Okay. And were these bags sealed?
Yes, sir.
Were you able to see inside the bags?
No, sir.
And you were given an inventory?
That's correct, yes, sir.
And that inventory was supposed to relate to you, the contents of those bags, right?
That's correct, yes, sir.
You have no personal knowledge of the contents of those bags, do you?
No, sir, I do not.
You've never seen them?
That's correct, sir.
And with regard to any broken glass you may have brought to Los Angeles, you don't know whether or not there was any blood on that glass, do you?
That's correct, sir.
And that's because you never saw it.
That's correct.
And you have no personal knowledge as to how that glass was broken, do you?
No, I do not, sir.
You have no personal knowledge as to where that glass was seized.
That's correct, sir.
You weren't in Chicago on the morning of June 13, were you?
No, I was not, sir.
Or the evening of June 13?
That's correct, sir.
How long have you been a detective, sir?
12 years, sir.
How long have you been a police officer?
23.
Thank you.
Now, Detective Hoover, with regard to, let's work in reverse order. With regard to the items that she brought back from Chicago, although you have no personal knowledge of those particular items, you still brought them back to Los Angeles in relation to the Simpson case, didn't you?
That's correct, yes, sir.
You got it from the Chicago Police Department, right?
That's correct, yes, sir.
Flew back here with them with your partner LaFall.
That's
right?
correct.
And you then booked them over at the Piper Tech to be held for this case. Isn't that correct, sir?
Yes, sir.
And what you have seen, you've seen photographs of those particular items that were seized in Chicago. Isn't that right?
Sustain.
Well,
Foundation.
all right. Have you seen photographs in connection with the items that were allegedly in that box?
Sustain.
Well, the photographs that you saw, where did you see the photographs?
I saw him in Chicago.
And these photographs you saw in Chicago had supposedly been taken by the Chicago Police Department?
That's correct, yes, sir.
And these photographs were taken of the items that were seized. Isn't that correct? Yes.
Sustain.
Well, tell us about the photographs that you saw in Chicago.
Counsel, the only thing he can testify to is a chain of custody, and he brought him back.
All right. You brought them back?
He brought 'em back.
Chicago, then. All right. Thank you. Thank you. But you then brought them back, right?
Yes, sir.
Did somebody tell you to bring these items back?
Yes, sir.
Who told you to bring them back?
Detective Lang.
But you also were an experienced detective yourself, and you knew to bring them back anyway, didn't you?
That's correct, yes, sir.
And you had a phone conversation with Lang, and then you brought them back, right?
No, I had no phone conversation with Detective Lang regarding that. I knew that I was going to go back to Chicago to pick him up. I was directed to do that.
All right. So you went there specifically to pick up these items from the Chicago Police Department.
That's
Right.
correct, yes, sir.
All right. And so you picked them up, you brought them back here to Los Angeles, right?
Yes, sir.
Okay, Detective. Now, with regard to the residence of Mr. Simpson on this occasion, you have indicated that you were upstairs in the bedroom and that you saw the condition of Mr. Simpson's bedroom. Did you not, during the course of the day after you arrived there at 12 o'clock or so?
Yes, sir.
And I want to show you, I want to approach and I want to show you a couple of photographs. One is People's 167 now in evidence, Your Honor, and one is one that I'd like to mark as a defendant's next in order. Quickly, 12,
1257,
1257. I'd like to approach, Your Honor.
please. '56.
66, thank you. I'm going to approach the witness by my, Your Honor. I want to show you, first of all, and I'll put this on the Elmo, I guess, People's 167, and I want you to see if you've ever seen that photograph before.
Yes, I have.
And you see on the bed there's something that looks like some kind of straps. You ever seen that day?
Yes, sir.
And what were those? What are those straps?
Those were luggage straps, or shoulder straps you would put on luggage.
All right, were those seized at all?
No, sir.
Were those moved at all?
Yes, they were.
And who moved them?
I did.
And with regard, I want you to take a look at 1256. Now, see that photograph, 1256?
Yes, sir.
And are the luggage straps depicted there also?
Yes, sir.
And they're in a different position, aren't they?
That's correct. One of them is.
And was that because you moved it?
That's correct, yes.
And you moved it prior to having the photograph taken or after the photograph was taken?
I don't understand your
All right.
question.
On this photograph here, 167, none of the straps are hanging down on the bed. Is that correct?
Okay, I understand. Yes, that's correct.
And on the other photograph, defendant's 1256 now, one of the straps is hanging down the bed. Is that correct?
That's correct, yes, sir.
Over the side of
Over the side of the bed. Thank you, Your Honor. And does that indicate that you had moved it at that point?
No, it had not been moved as of yet. The 3x5 that you are showing me was prior to me moving it, and the other one, the larger photograph, was after it was moved.
All right. Now, and look.
Records reflect that the smaller photograph that Detective Luper referred to was 1256.
Thank you, Your Honor. 1256. It appears that in 1256, the smaller photograph, something is hanging down the side of the bed, does it not?
That's correct, yes, sir.
Was that the condition you found it in?
That's the way it was found, yes, sir.
And then you then moved it up on the bed to take a picture of it?
No, I moved it so I could look underneath the bed itself, and then it was photographed.
I said, you actually moved this yourself?
Yes, sir.
All right. And so if we wanted to demonstrate that for the jury, we can show how it was found and how it was moved back. Is that right?
That's correct, yes, sir.
Okay. Let's look at 1256, first of all. Now that's the photograph, defendant's 1256. It's your testimony that you found this luggage strap, as you described it, over the side of the bed like that, hanging down toward the floor. Is that correct?
That's correct, yes, sir.
And you then moved that luggage strap.
That's correct, yes, sir.
All right. And at what time did you see the luggage strap in the condition is indicated in 1256?
12:35, 12:40 in the afternoon.
Were you the first police officer to go upstairs that day?
I was the only police officer who went upstairs, to my knowledge, to that point. We didn't have a search warrant.
All right. And you came back pursuant to search warrant?
That's correct,
Now,
yes,
there have
sir.
been other police officers in that house early that morning, have there not been?
I was not aware of that.
You weren't aware that Detective Furman, Detectives Lang, Detective Van Adder were in the house early that morning? Oh, weren't you aware they were there earlier?
No, sir, I was not aware of
What?
they were inside the house
Bev.
prior to that, no.
Ariel,
Detective Phillips was there also?
John, Terry.
correct.
Oh my
Aware that four of
goodness,
your brothers were in there
Helen,
early that morning?
I
Anna.
knew they'd been there. I knew they had been there,
Wow.
but I didn't know where they'd been in the house, if they had been in the house.
That's crazy.
Did you know
Hold on,
before
hold on.
LAPD officers?
No one
whose names I
talked.
just gave, Phillips, Van Adder, Furman, and Lang.
That's
had been inside
crazy.
Rockingham early that morning
Hold on,
June
hold on.
13th, 1994.
Yes,
So you were aware of that?
I was aware that they were on the premises, yes.
All right. As to whether or not they'd come upstairs at some point, you don't know, do you?
I have no idea.
All right. Now, with regard to 1256, which we've now shown, you then
Thank you so much.
moved
That's insane.
handles as depicted in 167. Is that correct? So if we look at 167, we notice now the strap is no longer hanging over the side of the bed. Is that correct?
That's correct.
And you say you moved that so that you could look under the bed?
Yes, sir.
Now, at the time, sir, that you said you made these observations at about 12 o'clock or shortly after 12 o'clock, is that correct?
The my initial walkthrough, or my first walkthrough, was around 12:35, 12:40, and then I was in and out of that room up until I left.
All right, and so that you made your initial observations, and then did you go in the bathroom area that we talked about before?
That's correct, yes, sir.
And you indicated and described for Mr. Darden that the place was rather neat, is that correct?
Yeah, rather neat.
And you didn't see things strung all over the floor there, did you?
No, sir, I did not.
In fact, when you went in the bathroom, the clothes that ultimately were taken out of the hamper were done so by you to look at them closely and inspect them.
That's correct, yes, sir.
And so as an investigator, you were looking for any kind of evidence in this case, isn't that correct?
That's correct, yes, sir.
And you looked through the entire hamper, and you looked through Mr. Simpson's clothes closet, and you didn't seize anything, did you?
That's correct, sir.
And even with regards to this glove that Mr. Darden asked you opened a drawer and you saw this brown glove, right?
Yes, sir.
And you, at that time, you told Mr. Darden that glove was a large?
Believe it was a large, yes,
It
sir.
wasn't extra large, was it?
It looked like a large to me. I couldn't
well-
tell you the difference.
Well, that's the point. Did you look inside the glove to see what the label may have said on that glove?
No, sir.
So when you told Mr. Darden it was a large, you just said that based upon looking at it, is that correct?
That's correct, yes, sir.
All right. You didn't look at any label inside there, right?
That's correct, sir.
All right. So you handled this brown glove and you brought it downstairs, and then you inadvertently put that glove on the table, right?
That's correct, yes, sir.
And you kind of forgot about it for a while, right?
Yeah, unfortunately, yes.
All right. And so that we're clear. At the end of the day, before you left, you took that glove back upstairs and put it where it belonged, right?
Not after the end of the day. I would say I had it back in my possession around 4:30, close to 5 o'clock.
And I'm saying by the end of the day, did you take the glove back upstairs at some point?
Yes, sir.
Did you put it back in the?
I put it back in where I'd found it.
Put it back where you got it from.
That's correct.
You didn't leave there with it, did you?
No, sir.
All right. And now, with regard to Mr. Willie Ford, were you walking around with Mr. Ford at the time he was taking these videos?
No, sir.
Were you outside the house at that point?
No, sir.
Bye,
Where were you?
Terry.
I was inside.
Where were you when Mr. Ford was taking his videos?
Could have been in several locations. I know I was upstairs in the bedroom and bathroom area, and I was also downstairs and upstairs and downstairs both.
You were still doing other work, is that correct?
That's correct, yes, sir.
Would you agree that Mr. Ford's testimony that he arrived about 3:10?
I would have to look at the crime scene log, but if it's on there and documented that way, I would have to agree.
Well, if he arrived about 3:10, would it refresh your recollection that he left about 4:30?
That's correct. If it's documented that way, it would refresh my recollection.
And I'll be glad to show that to you. Mike.
Yes.
So I'll just direct you to Ford and save some time here.
Yes, sir. I see the entry. It is 3:10, and he does indicate that he leaves at 4:30.
All right, you have no reason to quarrel with those particular times, do you?
No, sir, I do not.
Now, Dennis Fung, are you aware that Dennis Fung... yeah, maybe perhaps we should approach just for a second. All right.
We have a 7-minute video coming up next, and we're sped up a little bit. So this video is going to end, another one's going to start, and then end right away, and that's okay.
Thank you, Ed. With regard, sir, to Dennis Fung, you knew Dennis Fung prior to that day? Or did you?
I've only seen him at maybe one additional crime scene.
So you knew he was a criminalist for the Los Angeles Police Department?
I did, yes, sir.
And you saw him there on that particular date?
Yes, sir.
And did you see him on various occasions collecting various items?
That's correct, yes, sir.
And in connection with the log of the times that items were actually picked up, refer you to Defendant's Exhibit 1091, I want to ask you whether or not you ever at any time have seen the log of the collection of various items, okay?
Okay.
May I approach, Your Honor?
Yes.
I want to ask you to take a look, first of all, at this log, and then I'll ask you to look down specifically to items collected, and I want you to look specifically at I'm just asking to look at specifically, Your Honor. You look at items 12, 13, and 14. Just look down at those. Have you looked at the log now?
Yes, sir.
You recognize that as a log kept by the members of the Special Investigations Division regarding the collection of items at a crime scene?
Sustained. Phrase question.
All right, do you recognize that particular log and how it's used, sir?
I've never seen a log used like this before.
Have you ever seen a log used by the members of the Special Investigation Division at all?
No. I mean, I've never paid much attention to how they record their evidence.
Do you know who collected these socks allegedly on that day?
What I saw was Mr. Funk collecting them.
All right, and what time of day did Mr. Funk collect these socks? Well, without looking at the log.
Oh, well, there's no time on the log anyway, so it had to be in between 3:30, 3:45, somewhere in that general area.
3:30, 3:45?
Yes, sir.
Now, if,
Objection.
Overruled.
I haven't asked a question yet.
I know, if it was
Huh? If, I want to phrase this question, Your Honor, if I might. May I phrase the question?
proceed.
Now, with regard to Dennis Fung, have you had occasion to see his testimony in this court before this jury regarding the time that he picked these socks up, allegedly?
No, sir, I have not.
Have you had occasion to talk with Mr. Fung at all regarding the time these socks were picked up?
No, sir, I have not.
Are you aware of whether or not the Foyer blood drops, the socks were picked up sequentially or in order, from a standpoint of time, one being first and the other being second, then something was third? Are you aware of that?
No, I'm not aware of it.
Now, your estimate is that Mr. Fung picked these socks up at, what time was that now?
About 3:30, 3:45 in that general area in the afternoon.
And is that, you have that written in any report anywhere?
No, sir, I do not.
Who do you think would have the best recollection of what the time these socks were picked up, you or Mr. Fung?
Objection.
Well, I can ask that.
Sustained.
Well, may I ask another way, Your Honor? Who do you think would be in the best position to know what time these socks were picked up? The person who collected them allegedly, or you, sir?
Same objection. Your Honor.
Sustained.
Your Honor, I have another question I'd like to ask, if I might, at this point.
Do you want to approach before
Yes,
you
I
do
think,
that?
yes. Looper, do you know what time Dennis Fung collected, or Dennis Fung or Andrea Mazzola, collected the spots in the foyer?
Not without looking at their notes.
Would you like to look at their log?
Objection, Your Honor.
Well, if that refreshes recollection.
You can use it if it will refresh his recollection.
He hasn't testified that he ever knew.
Well, may I proceed? Will you look at this and see what, if you can look at this and refresh your recollections, what time they picked up the spots in the foyer?
According to their log, it's
Sustained.
Now, the proper way, I guess, Your Honor, having looked at the log, does that refresh your recollection as to the time that Mr. Fung or Ms. Mazzola picked up the, collected the spots in the foyer?
Objection, Your Honor. Lack of foundation.
Yes,
Overruled.
can you answer that?
it would appear by their log that they.
Objection, Your Honor.
Sustained. Phrase the question.
All right, again, I'll rephrase it again. With regard to the document I placed before you, is your memory refreshed as to the time Dennis Fung or Andrea Mazzola collected these spots in the foyer at Rockingham on June 13th, 1994, in the afternoon?
Foundation.
Overruled.
The log indicate.
Yes.
Now, first of all,
No,
does this-
question, wait, Detective Luper, the question is, is your personal recollection refreshed as, after having read the log, as to when those spots were recovered in the foyer?
No, sir.
All right, so you have no way of knowing at all.
No, sir.
Do you know whether or not that the foyer spots were collected prior to the time that you say the socks were collected?
Overruled.
Can we move that?
Yeah, would you?
Okay.
Thank you.
Yes.
I don't know how they were, if they were done in a certain order or sequentially. I know that Ms. Mazzola and Dennis Fung were working pretty much.
All right, next question.
All right, so, there's an objection to your question, right, Mr. Darden, so I didn't get a chance to finish hearing it. So you don't know, I guess my question was, do you know whether or not the spots in the foyer were collected prior to anything being collected upstairs?
I don't know.
You don't know, and the form that I've given you does not refresh your recollection?
No, sir.
And you've not spoken with either Mazzola or Fung about their testimony
That's
with the
correct.
jury?
That's correct.
And you don't know the times that they said?
That's correct.
Do you know the time that Mr. Willie Ford videoed Mr. Simpson's bedroom and there were no socks at the foot of that bed? You know that time?
Objection.
Overruled.
You know that time, sir?
I did not look at my watch on that particular day to be specific. No, sir.
All right, well, you weren't in the bedroom at the time Mr. Ford was videoing the area of Mr. Simpson's bedroom.
No, I
were you?
was not in the bedroom.
You were someplace else in the house, right?
That's correct. Yes, sir.
All right. He was accompanied by some other people, not you, right?
That's correct. Yes, sir.
Overruled.
Now, you mentioned, sir, that when you were downstairs, one of the reasons that you had inadvertently put down the glove that we talked about was because you were trying to follow some blood spots or wood spots or something?
They appeared to be red discoloration on the wood floor, and they appeared to be spots that were not one right after another, but fairly far apart from each other.
Did you pursue these spots?
Yes, sir, I did.
You found out later that was not blood, was it?
That's correct, yes, sir.
So it was kind of like a trail of no blood, right?
That's correct, yes, sir.
All right. Now speaking of that, by the way, as a detective, as the first person up those stairs,
Objection, that is simple fact not
well,
necessary.
Sustained.
the counsel's absolutely correct. As the police officer who went up the stairs after 12 o'clock on that date, you didn't see any blood on the stairs going up there, did you?
I didn't see any, no, sir.
You didn't see any blood on the carpet, Mr. Simpson's bedroom as you go in there, did you?
No, sir, I did not.
Now, with regard to these socks that you had seized, you didn't see any blood on those socks either, did you?
I didn't get close enough to examine them.
Is your answer you didn't see any blood on the socks?
No, sir.
And it's your testimony that you had these socks seized, or asked to have them seized, whatever time they were seized, because they were out of place, is that right?
They were out of place, and it seemed like a very good idea.
All right, and you had them seized, is that correct?
That's correct, yes, sir.
And you never got very close to them at that time?
No, sir.
And so I may have asked you this, you did not have the straps on the bed seized at any point, right?
That's correct, yes, sir.
Those were just left there, is that correct?
That's right, sir.
Have just a moment, Sheriff.
Certainly.
Detective Looper. Again, with regard to Detective Stryker, with regard to criminalists Fung and Mazzola, did you notice that as they were doing their work at Rockingham that day, they had kind of a clipboard or something of that nature where they were logging and writing down things as they would pick up various items? Do you remember seeing that?
Yes, I did.
And so that if you would see them at one particular area, they would then write something down on a piece of paper, although you don't know what they were writing, right?
That's correct, yes, sir.
In your experiences with me, you looked in the closet, and you never see anything there, right?
That's correct.
They did warn you.
You saw these suspenders, or strike that, you saw these straps on the bed, and you never sees those, right?
That's correct.
Took a glove from upstairs and brought it all the way downstairs, and you didn't seize that either, right?
That's correct.
It's your testimony that you saw some socks that were out of place, and you instructed that be seized, right?
That's correct.
And it's your best testimony before this jury that those items were seized about 3:30 to 3:45 on June 13th?
That general time frame, yes, sir.
All right. Thank you very kindly, Your Honor. I have nothing further.
Mr. Darden?
Just a few questions, Your Honor. And we are talking about general timeframes, aren't we, Detective?
Yes, we are, sir.
You weren't checking your watch to see when and the exact time that Mazzola and Fung picked up an item, were you?
No, sir, I was not.
You didn't think that was necessary, did you?
Overruled. Overruled.
You didn't think that was necessary, did you?
No, I did not, sir.
I mean, they're the criminalists, right?
That's correct.
It's their job to pick up and collect the biological evidence, right?
That's correct, yes, sir.
Not your job, is it?
No, sir, it's not.
You don't know the exact sequence in which everything was collected, right?
Overruled.
That's correct.
As far as the socks are concerned, you weren't looking for blood on the socks, were you?
No, sir, I was not.
You didn't want to get too close to the socks, right?
Overruled.
That's correct, sir.
Now, you told Mr. Cochran that you looked underneath the bed, right?
That's correct, yes, sir.
Finish sometime today?
Time this year, Your Honor. And can we approach it after reporting for a moment?
Do we have to?
I would encourage you.
You don't have to. Let me
Thank
show
you.
you a photograph marked,
535 and 536, Counsel.
Asking that we show some witnesses.
Yes, foundation first, please.
Detective Cooper showing you 535. You recognize that as the defendant's bed, right?
Yes, I do, sir.
Is that your hand in the photograph?
Yeah, it is. No. Sorry.
Is that hand smaller in your hand?
Yeah, it is.
Yeah, let me show you 536.
Yes, sir.
Okay. You looked underneath the bed, right?
Yes, sir, I did.
And you recovered something, or rather, you saw something beneath the bed, right?
That's right, I did.
And the thing that you saw beneath the bed is depicted in these two photographs.
Yes, it is, sir.
Five,
The other way around.
so.
Now, do you see an object there beneath the bed, Detective?
Yes, I do, sir.
That's the object that you saw, right?
That's correct, I did see that.
That object is a picture frame, isn't it?
Yes, sir.
And you pulled that picture frame out from beneath the bed and took a look at it?
I did, yes, sir.
And you had that photograph, didn't you?
No, I did not have that photograph.
Okay. But you now see a photograph of it?
Yeah, I do see a photograph of it now, yes, sir.
Okay. And Detective, when you first saw this item, this picture and picture frame beneath the bed, that was before the defendant came back from Chicago, wasn't it?
Yes, sir, it was.
That was before he was allowed access to the house, wasn't it?
Yes, sir, it was.
And let me show you 535, 536. Is that the item, Detective? Is that what you found beneath the defendant's bed?
Yes, sir, it is.
You know whether or not that's a wedding picture?
Stay. Move on.
Detective, prior to leaving the defendant's house, you straightened up some, didn't you?
Yes, I did.
You didn't want to leave his house in a mess, did you?
That was part of it, yes, sir.
Why not?
Sustain.
In any event, you did straighten up, right?
Yes, I did, sir.
And by the way, the woman in the photograph, that's Nicole Brown, isn't it?
Yes, sir.
Thank you.
Detective, are you married?
Yes, sir.
And I presume that years ago, before you got married, you probably dated, did you not?
Somewhat, yeah.
And may I proceed, Your Honor? May I proceed? May I proceed? You ever, if you had a picture of a girlfriend that you'd broken up with on your nightstand, and your new girlfriend came around, would you move that other picture away and under your bed, perhaps?
This is an interesting question. I don't think Detective Looper is the appropriate person to ask that
Very well.
question.
Thank you very kindly, Your Honor. Excuse me. Okay.
All right, Detective Looper, thank you very much, sir. You're excused.
I think, Your Honor, that's probably, the court is aware of our
Yes.
next witnesses, who they are.
All right. All right, ladies and gentlemen, as far as the jury is concerned, we will stand in recess. I've got some matters to take up with the attorney, so we're going to take our recess at this time. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, Mr. Blazier, people represented by Ms. Clark, and Mr. Kelberg. Jury is not present. Counsel, anything we need to take up before we take up the next witness?
Yes, Your Honor. I am down here not as a result of anyone else's efforts, but of my own accord, because I couldn't help on Friday but review the court's ruling with respect to Mr. McDonald's testimony, and then to review Dr. Reeder's report, my understanding being that Dr. Reeder's will be the next witness called by the defense. And it struck me as ironic, if nothing else, that in the court's ruling regarding Mr. McDonald, the court on page 2 of its ruling noted near the end, just before the section dealing with discovery violations, the previous evidence code section 352 objection by the defense to phenolphthalein-based presumptive test for human blood is still well taken for all the reasons previously advanced. And what struck me from that in the court's order is Dr. Reeder's report concerning his analysis of the test results of Mr. March from the FBI, because on page 2 in the concluding paragraph of Dr. Reeder's report, he says, thus, the finding of EDTA in a micro blood specimen, such as in the present ones, is consistent with, indicative of, and presumptive for the blood having originated from a specimen which has been placed into a usually lavender-top blood collection and then handwritten in as EDTA tube, such as is commonly used to draw blood from a living person and keep it from coagulating. What I believe the evidence would show, Your Honor, with respect to the analysis by Dr. Reeder's is there can be, among the 11 million organic compounds known in the universe, hundreds perhaps, that would give a reading, a pattern, to use a shorthand version, of findings consistent with what Dr. Reeder's in his report is only willing to say is a pattern which is consistent with, indicative of, and presumptive for EDTA. It seems to me that for all the reasons expressed by the defense to keep out phenolphthalein testing, because it's misleading, confusing to the jury of the real issues and so forth, the same applies with respect to Dr. Reeder's testimony, proposed testimony, with respect to the EDTA testing of the 2 blood stains. This is not evidence that in fact shows there is EDTA, according to Dr. Reeder's own report. It only reflects that the result is presumptive of EDTA. And we can go into the technicalities, but basically the full spectrum that you need to see in order to say, I identify EDTA, is absent. That it is not a full spectrum, and only what is present can be used to say, in the opinion of Dr. Reeder's, it is indicative of, consistent with, presumptive for. What's good for the goose, Your Honor, I submit, is good for the gander. Now, why is this important? Because if there is only one other compound in the universe, which besides EDTA could give the pattern, which is the pattern found in the stains from the gate and the socks, and from, I'll get into that, Ms. Clark, in just a moment. If there's only one other compound that could give that pattern, then the evidence may have far more probative value than if hundreds of other compounds could provide that result. But we don't know which hundreds could provide it, because, as the evidence would show, Dr. Reeder's, number one, has never done this test for EDTA using this equipment. His laboratory does not have this equipment. And the laboratory that he has to go to when he wants to use this kind of equipment does not have electrospray, which is in fact the process used by the FBI. But it's the FBI's report and analysis which Dr. Reeder's is going to come in here and talk about, supposedly. Now, I find it most curious that a man who's never done this testing for EDTA using this equipment, who doesn't have the equipment in his laboratory, and who has to go to a lab to do this kind of laboratory test, but can't do it on that equipment because it's not specifically the same kind, is going to come in here and start talking about, is this EDTA or is this not EDTA? And what's important is, all he's going to say, by his own admission, in his own report, is it's presumptive of. Let me give the court a further understanding of why I think it is so potentially misleading, and it is an example from Dr. Reeder's past, recent past. A very well-known case in the Southern California area, the Sconce, S-C-O-N-C-E case, oleander poisoning. The history, Your Honor. A gentleman was found dead in 1985, death attributed to cardiac arrest. A young man, a very overweight man, and a man in the funeral business, a competitor of Mr. Sconce's. There was an informant who, in about 1990, suggested that Mr. Sconce, or that the victim, had been poisoned by oleander poisoning. As a result of which, the Ventura County District Attorney's Office retained the services of Dr. Reeder's to perform an analysis of various substances preserved from autopsy to determine the presence of something called oleandrin, which is part and parcel of the oleander plant and is a toxin. Let me read the court just very briefly Dr. Reeder's testimony at the preliminary hearing in 1990, October 4th, regarding his findings. In this case, 3 independent tests were done: thin layer chromatography, fluorescent spectrophotometry, and radioimmunoassay. These are physiochemically different things. The chances that a substance has all the properties in all 3 tests in common and is in actuality another substance, and his opinion was that these tests showed it was oleandrin, from experience are so extremely remote that one then has a very high degree of scientific certainty that if one says that this is oleandrin, in fact it is. 100% never. For 100% you go to the seminary, because that depends on faith. Science is never 100%. It is statistical, and it is reasonably certain the chances are remote. And if you want to go over into the area of, in that area, the hand of Almighty God can make anything happen, so possibilities, of course, are there. But it's a high degree of reasonable scientific certainty, and the operative word is reasonable. A scientist goes by reason and not by feeling. Well, the defense attorney for Mr. Sconce didn't think going by feeling was a very good way to go either. So he proposed having additional and more sophisticated tests performed, and guess what? The prosecution, which included Mr. Giss of our office as a specially designated prosecutor for Ventura County, agreed to split the $20,000 bill to have the sophisticated testing done using LC-MS equipment at Cornell University. Incidentally, where Mr. McDonald, I believe, makes his headquarters, Cornell, New York. And that the testing was to be done to determine the presence or absence of oleandrin and another metabolite product. And guess what? Wasn't there. The testing by Dr. Henyon demonstrated that what Dr. Reeders was willing to say to reasonable scientific certainty, not to 100% because he's not God, it wasn't there. And guess what happened? A man charged with a potential capital offense saw his case dismissed as a result of Dr. Henyon's findings. And guess what further happened, Your Honor? Because I'm sure the court understands that before the prosecutor is going to dismiss a potential capital murder offense based upon an expert's finding, he's going to want to go back to the original expert, Dr. Reeders, and say, explain, please, where is Dr. Henyon wrong? Tell us. Dr. Reeders, I talked to Mr. Giss in Ms. Clark's office on Friday, basically gave a rambling, non-responsive answer. But a newspaper account of the story is succinct and to the point. From the April 4th, 1991 Los Angeles Times, Henyon reported last week that he had found no signs of oleandrin, but he said he was still looking for substances created when oleandrin breaks down in the body. After trial recess Wednesday, Henyon telephoned with his results. No evidence of poison. Reeders, reached at his home near Philadelphia, said he could not account for the difference between his finding and Henyon's. Quote, in science, unquote, Reeders said, quote, nothing is unquestionable, unquote. Now, Your Honor, I submit that this is exactly why presumptive test results should not be given to this jury under 352, because they are so misleading. They are not probative. Dr. Reeders cannot say what other compounds could produce the findings that the lab reports from Mr. Martz indicate. And to allow Dr. Reeders to give presumptive testing when the court sustained defense objections to presumptive testing is not to be fair to both sides in this case, using basically the same rule of law applied to the same general aspect of the case. Now, as the court will recall, when I was last here arguing the admissibility of Mr. Simpson's statement on the exercise video, I argued something on the assumption the court may not accept my position that the statement was admissible. That is, I wanted the tape played to show the physical movement. I make the same statement now that I made then, Your Honor, that I believe this motion should be granted. But I also feel it incumbent on myself to raise additional points in the event the court feels that the motion is not well taken. Number one, the oleandrin incident is a clear mistake by Dr. Reeders, which, using the rationale of the defense with respect to Dr. Golden, and of course that's really why I'm down here, because I have some familiarity with the evidentiary issues on this issue, where the issue is the competency of the expert witness, the court found that these specific examples of mistakes become admissible. And here, unlike Dr. Golden with gunshot wounds versus knife wounds, here we have the very same process taking place. Are we looking at something which is indicative of, consistent with, and presumptive for the chemical, or are we identifying the chemical in the substance? Big difference. And that's exactly what is at issue here, because I believe, I submit to the court, the evidence will show that, in fact, this is not EDTA. Agent Martz's unpreserved blood gave the same result as was found on the stains from the glove and from the gate. Not a quantitative result, but showing the same pattern, unpreserved. And that's a pretty interesting finding with respect to whether we carry EDTA in our system, if it's EDTA, or whether there are some other compounds that give the same pattern. So number one, the issue of does he get cross-examined if he testifies about his mistake? I submit to the court, using parity of reason, he gets cross-examined. Number two, and I mentioned this to Ms. Clark, is really why I thought it important that I come down and argue this point, because the court will recall in cross-examining Dr. Golden, Mr. Shapiro wanted to cross-examine Dr. Lakshmanan, wanted to cross-examine Dr. Lakshmanan regarding the legal implications from the mistakes in the Gay-Phillips case, which Dr. Golden acknowledged making. I think the court will recall that area of proposed cross-examination. And I objected to it on, among other grounds, that it's irrelevant. And that was because the issue for the mistake went to the competency of Dr. Golden. But I submit to the court that it is proper cross-examination of Dr. Reeders to show the legal implications from his failure and refusal to acknowledge that he was wrong. Because now we're not talking about his competency, we are talking about his bias. Dr. Reeders put his professional standing, his ability to get future business, his ability to retain his position as director of a laboratory above the liberty rights of Mr. Sconce, rather than acknowledge that Dr. Henyon's more sophisticated test proved that in fact there was no oleandrin poisoning. He takes the position in science, nothing is unquestionable. Goes to bias, the legal ramifications. So I submit to the court that if Dr. Reeders gets to testify, he gets cross-examined not only about the mistake, but he gets cross-examined regarding his response to that mistake and the legal implications from his failure or refusal to acknowledge it as a mistake, because he needed to place his selfish interests above those of Mr. Sconce, the criminally charged defendant. So, again, Your Honor, I raise these 2 points not because I believe our motion to preclude his testimony in its entirety is not well taken. I raise these points because I don't know how the court's going to rule, and I want to give the court the full picture of what I believe are issues related to Dr. Reeder's proposed testimony.
All right, thank you, counsel.
May I have just one moment, Your Honor? Thank you, Your Honor.
Mr. Blazier.
Good morning, Your Honor.
Good morning, counsel.
Let me talk about the second issue first. I think it's just absolutely outrageous that Mr. Kellberg would come in and read from a newspaper and argue that there's been some determination that Dr. Reeders made a mistake in the Sconce case. If we want to litigate the Sconce case, we can, but it's going to take us about a month. The testing that was done by Mr. Henyon was done on a 5-year-old autopsy, a different autopsy, different tissue than the testing done by Dr. Reeders earlier. Dr. Henyon, in his reports, my understanding, acknowledges that perhaps what Dr. Reeders saw might have been there when he saw it, but because the second autopsy 5 years later might not show the same thing. The case was dismissed. There were other reasons for its dismissal. We can litigate that from here to Sunday, and it's absolutely ludicrous to say that they should be able to cross-examine him on that kind of a case where there's been no legal determination that any mistake was made. In fact, no mistake was made. These are contrary opinions on scientific evidence, which happens all the time, and the notion that Mr. Kellberg would come in and raise his voice because a scientist would say he's not certain about something is outrageous. No scientist is going to get up there and tell you he's absolutely positive about anything if he's a real scientist. So I make a motion that they not be allowed to cross-examine on that issue at all, on 352 grounds certainly, and a lack of showing that there's any legal basis to cross-examine. As to the first issue on whether this is a presumptive test or not, first of all, Mr. Kellberg has not read Dr. Reeder's report carefully. His report states that the testing done by the FBI does show the presence of EDTA in the blood stain from the sock and from the gate. There's no language about presumptive for in that part of his report. The second part of the report, where he tries to attribute a source as to where this could have come from, is where he uses the term presumptive, not in the sense of a phenolphthalein test, where with a phenolphthalein test we know that there are a lot of common occurring substances that can give the same response as blood, and therefore it's only a test that narrows it down somewhat. Could have been something else, so they have to do follow-up tests to confirm it. These are not presumptive tests. I find it fascinating that Mr. Kellberg would use Mr. Henyon's LC-MS testing to prove that Dr. Reeders made a mistake when he's claiming now that LC-MS is just a presumptive test. That's the same testing that was done in this case. They might say that there are hundreds of compounds that could give this pattern. They can't name a single one. I asked Agent Martz. He can't name a single one. They have not looked at all 11 million organic compounds. There may be 11 billion in the universe. We don't know. So you can't absolutely say that there isn't something else out there that we've never seen before that might give this same pattern. That doesn't make it a presumptive test. I'm assuming that the Los Angeles District Attorney's Office has been prosecuting people for years based on LC-MS tests or GC-MS tests, which has less information than the tests run by the FBI in this case. Those tests have been used since the 70s to demonstrate that you have a particular substance in your blood, for instance. They're not presumptive tests. There's no case that says they're a presumptive test. They are determinative tests. They can make arguments that maybe there's some other compound out there somewhere, the name of which we do not know, that might give the same result, and Agent Martz will say that, and Dr. Reeders will say that as well. But they will also say that the only compound they know of that gives everything that we see here, namely the right retention time, the right parent ion, the right daughter ion, and the right other characteristics that you must have before something can even be tested, is EDTA. And Dr. Reeders will say, in his opinion, this is EDTA because it meets every one of those characteristics. As to the electrospray issue, electrospray is a process by which you move from the chromatography stage to the mass spec stage. With liquid chromatography, you're working with a liquid that has to be converted to a gas before you can do the mass spec part of it. All electrospray does is changes the liquid to the gas. It doesn't change the ions, it doesn't change the compound, it doesn't change the measurement system. You still wind up with chromatograms that you look at and you analyze. Saying that this should be determinative of whether an expert testifies is like saying that Julia Child can't tell you anything about cooking because she doesn't use a Cuisinart. It's one technique that's used as one step in the process. It's not, it doesn't change anything. You wind up with a chromatogram that's interpreted just like they all are. So I would submit that this is clearly not a presumptive test, and further that the prosecution should not be allowed to cross-examine on the Sconce case or any other case that they may not have mentioned unless they present it beforehand so that we can litigate that as well.
Briefly.
Number one, just for consistency, it's Dr. Henyon. It's not Mr. Henyon. Number two, it is a more sophisticated test than any of the tests that Dr. Reeders used. Number three, the evidence is clear. Dr. Reeders, in fact, we have his article, A Quest for Oleandrin in Decayed Human Tissue, noted. His findings showed it wasn't there. And he doesn't make any reference whatsoever to Dr. Reeders having been possibly correct in the past with respect to his analysis. If that were the case, this case might still have been prosecuted. We are not inclined to lightly dismiss capital murder cases, Your Honor. That is dismissed because of the overpowering and overwhelming and compelling nature of Dr. Henyon's results. Last thing is, who's the proponent of this evidence? The people at the left side of the council table, to my left. It's their responsibility to show no other compound. It's not our responsibility to say, oh, gee, you know, there's only one or two others or maybe a couple hundred. It's their responsibility. When they're talking about it's presumptive of. And that's really what the conclusion is. The issue for this jury is, hey, where does this stuff come from? If it's EDTA, where does it come from? And that's this issue that the jury is being asked to decide when, in fact, the expert, the best he's going to say is it's presumptive for. If he's using the language, I didn't put words in his mouth, I didn't put the words in this report, he wrote them. He should have to live by them. I submit for all the reasons previously expressed, Your Honor, he should be precluded from testifying. But if the court feels differently than I on this, that the two areas of inquiry that I've indicated are appropriate. Dr. Henyon's, I've asked Mr. Hodgman to make sure he's available to clear the air should there be any air need clearing regarding what the test results were, and I have every expectation that he would be available.
All right. For the purposes of the record, Mr. Blazier, do we have Dr. Reeder's report marked as an exhibit at this point?
I don't think we do. We provided it to the court last week.
I think we should have, I think for the purposes of the appellate record, I think we need to have a copy here.
I'll submit my copy, Your Honor.
All right. All right, the 352 objection as to Dr. Reeder's testimony regarding his testing for the presence of EDTA, the objection is overruled. I will allow his testimony. The cross-examination as to other testing and other cases done by Dr. Reeder's appears to be a fair game for cross-examination. Legal ramifications, however, of scientific testing appears to the court to be a 352 problem because there are many explanations as to why things are done legally. It's a apples and oranges argument, so the objection by the defense as to legal ramifications is sustained. All right. And for the purposes of the record, we'll mark a copy of Dr. Reeder's report as Court's Exhibit 18. All right. Deputy McNair, let's have the jurors, please. Doctor. Could you state and spell your name, sir?
My name is Frederick, F-R-E-D-R-I-C, Reeders, R-I-E-D-E-R-S.
Mr. Blazier.
Thank you, Your Honor. Good morning, ladies and gentlemen.
Finally, Reeders is on the stand.
Dr. Reeders, where and when were you born?
I was born in 1922 in Vienna, Austria.
And what is your occupation?
I'm a forensic toxicologist and director of a toxicology laboratory.
Could you tell us what toxicology is?
Toxicology is the study of chemical substances and of primarily biological systems in terms of focusing on the harmful effects that the chemicals can produce in the biological system. Simplified version, toxicology is the study of poisoning. And I deliberately say poisoning in quotes rather than poison because everything's a poison in too large a quantity. The definition of a poison is that it's too much.
Doctor, could you please tell us about your educational background?
Excuse me. Doctor, would you pull the microphone down, please? There you go. Thank you. Mr. Blazier.
I studied, my undergraduate studies were at New York University's Washington Square College, at Columbia University, at the University of Indiana in Bloomington, at Houston University, and a little bit on courses while I was in service overseas by correspondence from the University of Wisconsin. I received a Bachelor's of Arts degree
from New York University's Washington Square College in New York. In 1948, my major subject was chemistry. My minor subject was biology. I then went on to a Master of Science degree in chemistry, in which I specialized in toxicological analysis chemistry, in the analysis that is used at that time essentially in autopsy specimens. After I received a master's degree and became eligible to be a doctoral candidate at New York University, I was offered a special fellowship at the Jefferson Medical College of Philadelphia, which is part of Thomas Jefferson University in Philadelphia, in their School of Graduate Studies, not towards an MD degree, but towards a doctoral PhD degree. And there, during the following 2 years of work and 1 year of this, that, and the other thing, I received the degree of Doctor of Philosophy, again, not medicine, a PhD degree. My major subject was pharmacology, toxicology, pharmacology being the study of the effects of chemical substances from no effect through toxicology to a lethal effect, as well as what the body does to the chemicals, as it is in toxicology. And my minor subjects were pathology, the study of disease, and physiology, the study of the function of organisms, essentially the functions of the human organism of man. That was my formal education. Of course, I did research and presented a thesis on the toxicology of a substance called acrylonitrile, and I was granted the degree in 1952.
You spell acrylonitrile for the
A-C-R-Y-L-O-N-I-T-R-I-L-E.
Could you describe your other academic experience and affiliations?
Yes. While I was a graduate student at Jefferson, I was also a graduate assistant, and I did laboratory demonstrations in toxicology for the medical students. I did work for the clinic because I had some techniques from my previous work experience in lead determination in blood and other toxicological analyses, which were very rare at the time. Not many people had them, so I assisted in this sort of thing. I also participated in other research besides my own doctoral research. After I received a degree, I was appointed an instructor in the Department of Pharmacology and in industrial medicine as an assistant instructor. And I taught medical students, second-year medical students, toxicology, both in the laboratory and at lecture. I worked with other graduate students, and I conducted research in various areas of pharmacology and toxicology. And I lectured, of course, as I mentioned. This went on until 1956, at which time I had been promoted to assistant professor and had done research in pharmacology, toxicology, industrial medicine, and that incidentally included a lot of research with EDTA at the time, which had just come into use for the treatment of certain types of metal poisonings. In 1956, the city of Philadelphia changed from a coroner system to a medical examiner system. And the first medical examiner, Dr. Joseph Spellman, asked me to apply for the position of chief toxicologist upon the recommendation of my former chief, Dr. Alexander Gettler, who is sort of a granddaddy of American toxicologists, whom I had worked for at Bellevue. So I became an instructor, and then I left the employ of the city. I took an examination with several other people. I scored appropriately and was selected for the position of chief toxicologist for the city of Philadelphia and director of its, well, at that time, and starting a poison information center and directing it.
Let me back up just a minute before we get into your employment history, if we could. Have you told us about all of your teaching experience or academic experience with respect to professorships?
Well, only up until then. I remained on the faculty at Jefferson. I still am. I'm a full professor now. I became an associate professor and a full professor in the course of time. On a part-time basis, of course, and when the money crunch came, I agreed to forego my salary, which was minimal. It was a stipend, but I donated it to Jefferson, and I'm still on the faculty pro bono, which means I don't get paid for it. Now, for the last few years, I have not lectured to medical students, but I have worked with graduate students, continue to work with graduate students, and I'm starting a whole new course where I will start lecturing in the fall or in the spring.
Now, before we get into your employment history, could you tell us whether you have any affiliations with professional associations?
Yes. The first professional association which I joined was the American Chemical Society, of which I'm still a full member, as well as of several of its divisions, including the Division on Analytical Chemistry. Then later on, I joined several other societies that were particularly involved in pharmacology. American Society for Pharmacology and Experimental Therapeutics. I'm a full member of that. Some local societies, which since I no longer was stayed active, I dropped from. But I became a member of the American Academy of Forensic Sciences. I'm now a fellow, in particular of the section on toxicology, on forensic toxicology, of which I was was one of the chairmen for one of the sessions some years ago, and had various other official capacities in the Academy since about 1958 or 59, since I've been a member there. I'm a member of, and I'm one of the founders, one of the charter members of the International Association of Forensic Toxicologists, which was formed, I think it was around 1960, at a meeting in England. I was the first editor of its bulletin, which is, after finally somebody with a printing press made himself available, I ran on a Xerox machine for a couple of years. I'm a member of of several other organizations. I am a member of the American Association of Forensic Toxicologists, which is called Society of Forensic Toxicology, which is somewhat similarly composed and somewhat similar to the activities of the toxicology section of the Academy of Forensic Sciences. And I got certified by the American Board on Forensic Toxicology, which is part of the Academy, as a fellow, as a board-certified forensic toxicologist. I'm also a member of the American Association of Clinical Chemists. Those are the chemists who work in hospitals and in other places, mainly to help in the diagnosis of disease. There is a section, an area in it, a specialty of toxicology, of toxicological chemistry. And I am board certified in toxicological chemistry by the American Association of Clinical Chemists. I'm a member of an international association on risk analysis and several others, but these are my main professional background organizations.
Now, could you tell us a little bit about, briefly about your employment history prior to the time that you started your own lab?
Well, I want to tell you all the different jobs I had when I came here as an immigrant, which was from steve door to glassblower to anything you could do in 1939. But my first related position developed in 1941 when I became an assistant chemist, of all things, in a soda factory, in preparing flavors and doing preparatory analyses. After that, I worked for another chemical company that made detergents and a variety of other things as an assistant chemist, and then I went into the service. I was in the military during World War II as a surgical technician, and then as a interpreter because of my various language skills. That was towards the interpreter was at the end, towards the end of the war, and then for a year or so afterwards in military government. When I returned to the States, I continued under the GI Bill with my college education, but after 1 year, all I had left were some rather easy courses, so I sought employment, and I received a job through the Employment Service as a junior toxicologist, a trainee in toxicology, in the office of the Chief Medical Examiner of the City of New York, and under the Chief Toxicologist, Dr. Alexander Gettler and Dr. Charles Umberger. I was there for approximately 2.5 years, being trained there and actually performing service work, of course. I then, as I mentioned, went to Jefferson, and I took you through the time that I left my full-time status as at that time, assistant professor, and became chief toxicologist for the city of Philadelphia. My job at that point in time was to organize a laboratory and a division of toxicology. There was none in the medical examiner's office because the medical examiner had just been established, and also to organize and direct the Poison Information Center for the city. After that, what I did is the medical examiner's office was in the health department of the city. I conducted toxicological analyses on autopsy cases for the medical examiner, assisted hospitals in the differential diagnosis of poisoning. At that time, that's about the only source they had for laboratory work, is to avail themselves of the medical examiner's toxicologist. I did some consultative work for a variety of city agencies, and I started to train and conduct research in toxicology as well. I did that from 1956 when I became chief, and I organized and directed the Poison Information Center. I did that until 1970 for 14 years, and
Is Office of the Medical Examiner, is that similar to what we call a coroner?
very similar, yes. The operation that was here, the toxicologist that was here was a colleague of mine that I knew very well for many years, and the the coroner I knew very well, and I still know all the people quite well in the ME's office here. It's very similar. You have I think you have a coroner's medical examiner or a coroner's chief forensic pathologist. So it adds up to the same thing. It's just a politically different issue. The medical examiner is appointed upon examination and selection.
This is not your employment history. Ask another question, please.
Can you tell us from 1956 to 1970, when you were with the medical examiner's office, approximately how much of your work involved working with law enforcement agencies?
Well, it all related to law enforcement agencies. We had a weekly conference with the chief of the DA's homicide division, with the chief homicide detective in the city of Philadelphia, going over all the homicide cases. But the office was independent of the law enforcement agencies as a very important part of its function, and that is to be an ombudsman in cases for the medical examiner, not the toxicologist, to determine the manner of death, whether or not criminality might be involved.
Now, from 1970 to now, what's your employment been?
Well, in 1970, I left the employment of the city and started an independent laboratory and consultative company, National Medical Services, in which at that time I continued to do a lot of post-mortem toxicology for the surrounding counties.
I'll get into the specifics of that, but how large is National Medical Services now?
Well, now it has 120 people in it. It's not my doing, that's my son's.
And does that company do business with law enforcement agencies?
Yes, indeed.
Approximately what percentage of the work is done for law enforcement agencies?
The forensic work that we do is perhaps as much as 20% of our work.
Could you give me just a real rough list of some of the law enforcement agencies that you work for?
Well, we work for many of the police departments in the surrounding counties, for the district attorney's office, for cases that they bring to us in the surrounding counties. We occasionally work with the police department and the courts in the city of Philadelphia, too. We are outside the city. So we assist there on, well, either the courts themselves or sometimes the defense attorneys. It makes no difference.
Do you work with...
We also do work for police departments at times in New Jersey, as far away. Well, we have done work for the Los Angeles Police Department at one point, or we may have done some more recently that I don't know of. So we do it for all over the country.
Do you do work for any foreign police agencies?
Yes, occasionally we did some work for the medical examiner and the prosecutor in Brazil, in one of the countries. Puerto Rico, of course, was part of the United States. We have done work there. We've received specimens in 3 criminal cases, potential criminal cases, from Australia, one of which is specifically from a police department, the other one's from a medical examiner, third one a private party, recently.
Does your lab do work for other labs?
It's a major part of our work is reference work. That means work that large laboratories, which do a lot of clinical analysis, get, and that are specialized toxicological tests, and they send them to us with their reference lab.
Can you give us an estimate of how much of your business is actually work that other labs send to you to do for them?
I can only give it to you for the time while I was administratively involved in the company, which stopped about 3 or 4 years ago. And at that time, it was about 30% or 40% was reference work from other laboratories.
Now, do you have an ongoing working relationship with the FBI?
Yes.
Now, I don't want to mention any specific cases, but are you currently working with Agent Roger Martz of the FBI on some criminal cases?
Well, we are really not actually working on them, but we are discussing how to work on them that we have, yeah.
And does that work involve detecting or developing methods to detect the presence of poisons in tissue?
In one case, it will involve the development of methods. In the other case, it will be what analysis will the FBI do or has done already, and what analyses will I do because of my capabilities.
And just Special Agent Roger Martz is sitting right behind us, right?
Yes, of course.
Now, could you tell us very briefly when you started doing work with chromatography?
Well, I started doing work with paper chromatography, which was the first form of chromatography that came out while I was still a graduate student. So that was in, let's say, 1950. I started doing thin layer chromatography, which is a more modern method, and used it extensively following a Gordon Research Conference in which I participated in 1959 or 60. Same year, I started working with gas chromatography, 1959, 1960. I started to work with gas chromatography coupled, hyphenated, the hyphenated systems, with the technique called mass spectrometry, in the 70s.
Now, was that around the time when that technology actually was started?
Well, the technology started earlier as an academic research technology, but it's around the time where there were beginning to be some bioanalytical applications for real-life situations.
Now, have you done work in what's called HPLC, or high-pressure liquid chromatography?
Yes, I have.
Since about what time?
1973, I think 1973 is when we got our first instrument, after I'd familiarized myself with it for some time prior thereto. And so that's about when I started to actually hands-on do a lot of work on it and then supervise a lot of work.
Do you currently in your lab do mass spectrometry?
Oh, yes, we do.
And how many instruments do you have that do mass spectrometry?
7 or 8.
Now, we'll get into the details of what that is in a second, but have you done what's called tandem mass spectrometry?
Yes, I have.
Approximately how many times?
A few times, or hands-on only.
Okay.
It's, again, that is a relatively new, not commonly available technique in toxicology labs, at least.
Could you tell us briefly what is EDTA?
Well, EDTA is the name of a chemical substance which in full is called ethylene, E-T-H-Y-L-E-N-E, diamine, D-I-A-M-I-N-E, acetic, A-C-E-T-I-C, acid. Ethylene, diamine, tetraacetic acid.
I'll put up slide number 1 in my... This would be the 1257 series. This would be 1257A. Doctor, can you see the monitor right there to your right?
Yes.
Is that is that what EDTA is? What you just
Yes.
spelled? Okay. Could you tell us what a purple or lavender top tube is?
That name is in medicine, in laboratory medicine, or anyone who uses human blood for testing, the name for an evacuated tube which has a stopper that is, some call it lavender, some call it purple in color, and that makes you recognize it clearly as a tube which has EDTA in it.
I have a photograph marked as next number. 1258.
All right.
And I'll have this put on the Elmo plate.
This is a photo of tubes.
Yeah.
1258, Mrs. Robertson, photo of tubes.
Doctor, could you look at your monitor and tell us if that appears to be 2 purple top tubes?
That is the typical appearance of the purple top tubes, yes.
Now, what is the relationship between EDTA and a purple top tube?
Well, EDTA, either as a potassium or a sodium salt, is put into the purple top tubes, which have a vacuum in them, so that when blood is drawn and mixed with it, that blood won't coagulate. That's the sole purpose. It has some preservative properties for certain types of cells and other things, but what the EDTA does, the EDTA is what's called in English a claw compound, like a lobster's claw, a chelating agent. And what the excess of EDTA does, that's in the tube, is combine with all of the calcium in the blood and tie it up. Without calcium, blood won't clot. If you don't do that, then the blood will clot in 5-7 minutes.
Now, you had experience in your background working with EDTA.
A great deal, yes.
And approximately when did you do your first work with EDTA?
In the early 50s.
And just briefly, what was the nature of that work?
The first thing that I became involved in is to study its properties as to whether or not it could be used for treating acute lead poisoning in small children who were at the Jefferson Hospital, and then in working with one of the physicians in administering, in designing doses, administering it, collecting blood and urine, and measuring the lead that's coming out of the child. Then this was expanded to working with it in occupational employment cases where people are exposed to lead, battery workers and others, both in treating their kind of lead poisoning, which is different from what is in children, but also we developed a diagnostic test for somebody to determine whether or not someone had an excessive body burden of lead and therefore should be treated even before they got really sick. So all that was published work. And then I did a substantial amount of test tube work with EDTA and also experimental work with animals. I also did experimental work, or rather studies, it wasn't really experimental, it was clinical work, in determining how EDTA mobilizes and causes the excretion of other elements besides lead. Again, with published work for copper, for zinc, for a number of other metals that EDTA can chelate. In the process, well, this was the biological work. The in vitro work was measuring the strength of the way that EDTA holds on to metals. How easily will it rip it away from some part of the body, how it will redistribute the lead, and whether it's absorbed. I fed in animals, not in man. We did not feed any people because we came to the conclusion that oral EDTA can only do harm rather than good to people who have metal poisoning.
Some of that work involve analyzing biological samples for the presence of EDTA?
Some of it did, yes.
Starting about when?
I made some attempts at analysis of EDTA as early as 1954 or 55. They were successful for qualitative tests in urine, but not for anything else. They were color tests of a sort. I did a lot of tests, not a lot, some testing for EDTA while I was toxicologist for the city, because ever so often I would receive a blood specimen and I needed to know what was the preservative. And the pathologist couldn't help me, didn't remember whether he had dumped in blood from reagents from a lavender top tube or from a gray top tube. A gray top tube has fluoride and oxalate in it, or whether he didn't put anything in. After death, blood stays fairly liquid. It clots, but then it liquefies again. So you can't really tell. If you get a tube of clotted blood, you know that's blood that has not been preserved with anything, usually. That's why it clots quickly.
Have you worked on chromatography techniques to detect the presence of EDTA?
Yeah, that came later.
And that started about when?
Oh, I started to do some of that around 1976 or 77. But it isn't for detecting EDTA at ultra-trace levels. It's to determine whether a blood specimen is an EDTA specimen, has a lot of EDTA in it, or whether it's a fluoride oxalate specimen, whether it's been preserved with that. More recently, I'm able to determine whether heparin was used. I couldn't do that until recently.
Doctor, I didn't ask you about your publications before. Have you published articles and made presentations in your area of expertise?
Yes.
Approximately how many?
Over 100.
And do you know approximately how many of those, how many of your articles are in peer-reviewed journals?
What?
How many of your articles appeared in peer-reviewed journals?
I think well over half.
And did some of those articles include articles about EDTA?
Yes.
And approximately how many?
A dozen or so.
Now, were you asked to review results of a study performed by the FBI to determine whether there was EDTA present on bloodstains found on a pair of socks found in Mr. Simpson's bedroom and from a bloodstain found on the back gate of Nicole Brown Simpson's condo?
Yes.
And have you examined test results produced by the FBI on those questions?
Yes.
Have you also examined a validation study that the FBI performed in February of this year?
To the extent to which they were submitted, yes.
Incidentally, at one point were you consulted by the Los Angeles Police Department during the course of this case about methods to detect EDTA in bloodstains?
Yes.
You remember who that was?
Mr. Henkhaus, Henchaus.
And did you provide him with some materials to assist them in developing a method to detect EDTA?
Yes, of course.
Now, do you have an opinion as to whether the method used by the FBI to detect the presence of EDTA in bloodstains is a valid method for detecting the presence of EDTA in blood?
Yes, the method is valid. It is capable of detecting EDTA, of identifying it, of measuring it, even if not the way it's done. The measurement is, you can't really make any quantitative measurements too readily.
In terms of determining whether it's there or
whether
not.
it is there and whether it is there in a range, a very wide range of amounts.
Now, when we talk about amounts, do we use the term parts per million?
No, that's concentration.
Concentrate, okay.
That's a different.
And tell us briefly, what is, when you use the term parts per million, what does that mean?
It means one part, in the case of EDTA, in 1 million parts of blood. This would mean, for instance, 1 microgram per milliliter, which is 1 gram, or 1,000,000 micrograms of blood. That's 1 part per million.
Did the method developed by the FBI that you reviewed, in your opinion, is it capable of detecting amounts of EDTA in blood in the parts per million range?
Yeah, in the range of maybe 10 parts per million and higher, perhaps somewhat less than that, perhaps 5 parts per million and higher.
Now, is parts per billion 1,000th of parts per million?
Yep, it's 1 billionth, and a billion is 1,000 million.
But if you're relating parts per million to parts per billion, you're talking about 1,000th as much of something in parts per billion.
Yes. There are 1,000 parts per million in 1 part per, there are 1,000 parts per billion in 1 part per million. They are the same. 1,000 parts per billion or 1 part per million.
Now, Doctor, I want to ask you some questions about EDTA and what characteristics the FBI was looking for. Can we have slide C? Now, do chemical compounds like EDTA have what's called a molecular weight?
Yes, sure.
And is this isn't in pounds or ounces, is it?
It's in units. The molecular weight is how many hydrogen atoms you can cram into a molecule to get the same weight. That's the unit. The weight of hydrogen is nominally 1. So something that has a molecular weight of 292, as we have here, and 292 is the molecular weight, is as big, weighs as much as 292 hydrogen atoms.
So what is the molecular weight of EDTA?
292.
And I assume different compounds have different molecular weights?
Yes, there are other compounds with 292 weight, but they are not terribly many.
Is 292 a relatively high molecular weight?
Relatively high, yes.
And
as you go higher, fewer and fewer compounds will have exactly the same weight.
Now, looking at the chart on the screen, the chart indicates adding a proton to 292 gives you what?
293. The
And
proton's the same as a hydrogen atom with a charge on it, positive charged hydrogen atom.
And why do you need to have a charge on it?
Well, you need a charge on an atom in order for the principle of mass spectrometry to measure it. The mass spectrometer measures charged atoms, measures the charges. And what it does, it gives you a number which is the ratio of the mass, the molecular weight, over the charge. In this case, it would be 293 over 1, so that the ion that you then have, which is EDTA with a positive charge hooked on its head, has a weight of 293, and the charge, m, that's the mass, 293, the charge is called Z, like zebra, over 1. So it's 293.
So is it fair to say that if you were looking for EDTA in a substance, one of the things you'd look for was whether you had something that weighed 293?
Yes.
And what's that called, 293?
That's called the parent ion. It's the whole molecule plus a charge on it. So it's an ion. The whole molecule doesn't have a charge on it, but it gets a charge on it, and so it's called a parent ion, because from it can come fragments.
Now, could we have the next slide, slide B? Now, Doctor, please look at your monitor, and the bottom part of that diagram indicates that the parent ion is broken into pieces. Is that correct?
Yes, that is the function of the mass spectrometer. First thing it does, it weighs the ions that are there. It weighs the molecule. The molecule, in order to be weighed, has to have a charge. So it adds a proton and then weighs it. So it gets a 293, which is the molecule plus 1. The molecule, remember, is 292. Then it breaks that molecule into pieces, but not the way that you break a bottle of beer, but the way that the jeweler cuts a diamond. It breaks it along certain planes and not others, so that the pieces that result are somewhat predictable from the structure of the compound. If you apply energy to it, it'll break up into certain kinds of pieces. Now what it does, it weighs the pieces to see what weight do they have. In this case, one of the pieces, one of the daughters, you might say, of that 292 after it was broken up, has a weight of 160. And so that you now have two identifying characteristics. You have there is a substantial amount among all of the ions of a 293, enough so you can weigh it, and there is enough of the breakup product 160 so you can weigh that.
I now want to talk a little bit about chromatography. Could we have slide F? Your Honor, the last slide was 1257D.
Thank you.
This is 1257F. Now, the process that was used by the FBI in this case involved a step called chromatography and then a step called mass spectrometry, correct?
Yes.
Now, chromatography, could you describe briefly, looking at the chart up there, what is the principle of chromatography?
The principle of chromatography is the separation of compounds that are mixed together by having them go for a walk. So it's characteristic. For instance, you take a group of people, a whole bunch of people, and you say, now, I want you to walk from here to a mile from here as fast as you can. You all start at the same point. Gradually, over that mile, it spreads out until the EDTA person is somewhere there, and all the others are also spread out. Good chromatography separates a mixture into all of its components, or all of the components that you're interested in at least. And then at the end of the mile, there's someone with a camera who takes a picture of the person coming through the end gate and determines how long it took from here to the mile from here. It says that is the retention time. That's how long that person was retained on the road to the goal.
Let me go to the next slide and see if we can illustrate that, which will be G. Now, in my example, I've used a red square as an EDTA compound molecule and two other ones, one green and one yellow. The column that's indicated on the diagram, what is that?
That is actually a glass or a metal column which is filled with a material that the person can lean on, so to speak, if you make it a parallel to this, so that there are things along the mileway where you can stop and lean on if you want to for a little before you go on. What's driving the material through that column is a liquid. In this case, in the illustrating case of people moving as fast as they can, the drive is more inward, you know, if you want to win or you just want to make it to the other end. But what is moving you is your muscles through gravity. And some people lean longer and others lean less long, and so they start spreading out. So the column is packed with the material, and it's the mixture is pushed through the column with the liquid at a steady rate. As the mixture goes through the column, it leans on and releases from the column the different compounds, different number of times, so that again, by the end of the column, they are separated from each other. In this case, the EDTA is the slowest that I had here. It's the last one out of the column. Other things before it came out before.
Now, in the diagram, I have a clock at the top and a clock at the bottom. Is that to represent the amount of time it takes the EDTA to get from the start, go through the column, and come out the other end?
Yes, that is the stopwatch, and what it measures is the retention time.
And is that one of the things that you look at to determine whether you have EDTA in a substance?
Yes, in a good system, you can repeat that. You can take another sample of the mixture and throw it on the column and push it through, and the retention time is going to be pretty much the same, close to it, within what you allow as experimental error. It won't be the same to 10 decimals in time, but it should be close enough so that you can say, well, when I see something coming up at that time, I better think of EDTA. And that, you know, that's what EDTA does, so it could be EDTA.
Now,
it's consistent with it.
And can you also put known EDTA into the system to see how much time it takes to get through, so you have some sort of a benchmark to...
Well, you start out with known EDTA, just to determine its retention time. But since from day to day, and actually from run to run, you can get differences, what you like to use is another substance, which you also put in yourself at the same time, which also has a known retention time, but more importantly, is closely enough related to the EDTA, so that if there's going to be a change in retention time for the EDTA, there'll be a similar shift for your known substance that's called an internal standard. So now, instead of saying it took 2 minutes for the EDTA to come out, you say it took twice as long as it does for the control substance, for the internal standard, which took 1 minute. The next time, maybe you really have a very different column, and it takes 3 minutes for the EDTA to come out. It'll take 1.5 minutes for the internal standard. So the ratio will remain the same. It's a very important part of reproducing your values as closely as you can.
Okay, we'll talk more about that in a few minutes. But now, the technique that was used by the FBI is called liquid chromatography, correct? And does that mean that it's a liquid that they push through the column that might have had EDTA in it?
Yes.
Now, the next stage is the mass spectrometry stage, correct?
Well, actually, the next stage is getting it from the end of the column to the mass spectrometer.
And that, to be put through the mass spectrometry, does it have to be a liquid or a gas?
Well, it has to be either particles that are so fine that they are virtually no bigger than gas molecules or that they can move, or it has to be a gas.
And now, using liquid chromatography, if it comes out as a liquid, how do they get it to a gas or to a small misting particle?
Well, originally, way originally, what you did is you watched the liquid chromatograph and the detector, and when the peak started to come out, when one of the molecules, or of course a lot of them, because you put in not just one molecule of each one, whatever came out, you caught it in a net, in a fraction collector. Then you took that fraction and you put it into a tiny glass vial and evaporated off the liquid part of it so that you had a solid in it. Then what you did is you shoved that vial into the mass spectrometer and you heated it up until the material in the little vial on the probe evaporated, formed a gas, and then it could react in the mass spectrometer.
What technique did the FBI use?
The FBI used a method where the liquid goes into a very tiny, but moderately long piece of a glass capillary. It has a tiny, it's a glass tube with a tiny opening and a tiny run. That is heated and has applied to it a very high voltage and a moderate amperage, high electricity. That's why it's called electrospray. At the same time, a gas passes over it, a sheeting gas and a separating gas. And what happens is that the liquid at the end of the capillary is sprayed out, and in minuscule form and dry form, the water is removed by the sheeting gas, goes into the mass spectrometer. So it's one way, and it's the most recent way, and one of the most efficient ways of getting the sample in there. Before that, you turn it into a gas in a chamber, and then you put the gas out through a small opening which was partly open to the open air, so that much of the carrier gas would go out into the air, and the stream of vapor of the molecules that you wanted would go in. And that's a much less efficient way of transferring from the column to the mass spectrometer.
The electrospray process, does it change any of the ions?
No, it doesn't. If it changed the ions, then you basically wouldn't know where you stand.
Now, electrospray, is that do you use that technique in your lab?
No.
And is that a fairly expensive piece of equipment to use?
Well, yes, of course, all equipment is expensive. All of this type of equipment is expensive, but it is of relatively recent origin. It's the most up-to-date transfer of molecules in the Hewlett-Packard instrument. And as a commercial laboratory, we have to wait until something has proven itself before we put out $750,000. So we are not the first ones, but also not the last ones to get it. And in time we will.
Now, I'd like to move on to slide I and get into the mass spectrometry part of this process. Now, does the mass spectrometer have a way of looking to see whether the 293 parent ion is there?
Yes.
And how does it, just very briefly, how does it do that?
Well, basically what the mass spectrometer is a piece of equipment which, to characterize it, weighs the particles that are in there, sorts them out into groups, into 293s and others, and then weighs how many of those particles are there, what's the intensity of that ion. Then that's a regular mass spectrometer, single-stage mass spectrometer.
Now, in the kind of testing that was done here is a filtering system set up so that only the 293 parent ion gets through.
Well, then, in this case, what you do is you set up a filter, and you set it so that only the 293 will get through. That's done both in terms of the mass, but also in terms of charge, and such a filter works quite nicely. So you isolate from the others the 293 ion. Now, what you can do is put it on a detector and say it's present, period. Or you can put it into a second mass spectrometer, but in fairly pure form. You just have 293 molecular ions there. All the other stuff that's in there is not going with it.
Okay, let me put up slide J. Now, is that an indication of just in chart form, of the parent ion getting through the filter and other ions not getting through?
That's what a filter does. It keeps the other particles out, and the 293s go into the next place, which is either a detector, which says, yeah, there are 293. I'm seeing things, and the filter's taking everything out except the 293. So what I'm seeing is 293.
Now, can we have chart K? Now, is there a second step in order to look for the daughter ion?
Yeah. If instead of going to a detector only, it is detected, but it also is then put into another mass spectrometer by the system, then that mass spectrometer again breaks the 293 the way a jeweler breaks a piece of a diamond. He starts out with a 10 carat, he breaks it down to 3, 2, etc. Then he takes one of the 3 carats and cuts that further.
Can we have slide L, please?
I mean, hell no, you may not.
Now, does this chart indicate?
Whew, John, we did it. We did a 3-hour stream today on that. I'm glad we went as far as we did. I hate to tell you guys, but he's in at least 2 more videos, probably 3. At least 2 more. We're not done with this one, though. We still have 45 minutes to go on this one, but we're sped up. And the third one's only 45 minutes itself. So maybe by the end of the week. Nope, today's Sunday. Today's almost the end of the weekend, so no. We won't get it done by the end of the weekend. Guys, thanks for coming out for this long OJ stream. All 11 of you. Wow. Average view duration is 46 minutes. That's insane. I've never got that high in any of my live streams before. Well, maybe my 7-hour ones. That's a very high one. You guys stuck with it like champs. The good news about what we did today is we had some short videos in here, so we just got through a bunch of video. We're gonna get through a bunch quickly now. Yeah, the EDTA, abso-freaking-lutely. If they can prove there was a substantial amount of EDTA on any of that blood, all of it is suspect now. All of it. They just need one little piece of that blood to contain enough EDTA. Now, it didn't happen because obviously we would have heard about that throughout our lifetimes. You know what I mean? He would have been. I don't know. I feel like we would already know that. It wouldn't be the glove that got him off. It would be science. But it teaches you don't plant blood. Life lessons. All right, guys. I'll see you again soon. I hope you have a great day. Bye.